Okay, welcome everyone to
Right here.
I'm waving so you can see where I am. This is Paul Kramer, the chair of the Committee of Bar Examiners, welcoming you.
Have a seat.
Robbie, can you maybe mute your room when you're not talking? You see there's a button on the controller there?
Okay, are you gentlemen here for the CBE meeting?
Yes.
Okay,
Yes.
I'm gonna mute.
Okay, great. Thank you. Again, I'm Paul Kramer, chair of the Committee of Bar Examiners for this meeting and perhaps one more that will occur in early September. Devin, welcoming you to the August 18, 2023 meeting of the Committee of Bar Examiners. So first order of business is to take our roll. Devin?
Dr. Bolton, Robert Brody,
Here,
Dr. Cow,
here,
Alex Chan,
Here.
Jim Efting,
Here.
Kareem Gangora,
Here.
Dolores Heisinger,
Here.
Larry Kaplan, Paul Kramer,
Here.
Alex Lawrence,
Here.
Esther Lynn, Bethany Peak,
Here.
Ashley Silva Guzman,
Here.
Vince Reyes,
Here.
David Torres. We have a quorum.
Okay, thank you. We'll take public comment in a minute, but I want to first alert the committee members and the public about a change in the order of our items today. The law school performance item under educational standards, it's item H, will be heard after the first year exam tracking report which is under examinations. And that item is time set at 10 a.m. this morning. For those of you viewing this meeting via Zoom, closed captioning of the video feed is available. To view those closed captions, hover your mouse on the lower portion of their screen where the Zoom toolbar is located. There should be a section on that toolbar labeled CC. Select that option and then select Show Subtitles on the pop-up menu. For those of you still having technical difficulties, please don't hesitate to contact State Bar staff for further assistance. If you're viewing the meeting recording after the meeting on YouTube, the YouTube video player has a similar function to turn the captions on and off. Just be aware that when we share a slide deck, a document, or a proposed motion on the screen, that the captions may cover them up to some extent. So if you don't need the captions, I would say leave them off so that you can see the full breadth of our video presentation. The Board of Trustees has adopted a public comment policy. It applies to all bar committees, including this one. And it says in part, the State Bar of California welcomes public comment at all of its public meetings and appreciates listening to a wide variety of viewpoints that reflect the diversity of California. These public comment rules are designed to ensure that members of the public may exercise their right to be heard, as well as ensure that the State Bar is able to fulfill its obligation to conduct business on behalf of the people of California in a timely fashion. Written public comments may be submitted to the email address on the meeting agenda. We encourage people to submit those written public comments at least 24 hours prior to the start of a meeting. Comments received less than 24 hours prior will be distributed the following business day. Written materials brought to a meeting for distribution will be collected by the meeting secretary and distributed after the meeting concludes. For oral comment, persons were encouraged to sign up to speak in advance of the meeting and will be called in the order they signed up. Persons attending the meeting remotely will be called in the order that they appear on the attendee list. Speakers cannot cede their time to another speaker, and it is not guaranteed that all who wish to speak will be able to do so. To facilitate hearing from as many persons as possible, we encourage you not to repeat points that were made by previous speakers. simply say you agree with them. To allow the committee the time needed to deliberate on the important topics we will be discussing today, we will be limiting comments to 3 minutes per person. Law school deans or a designated law school representative may speak at the time items specific to their school are heard by the committee, following the staff presentation for up to 5 minutes. Others who wish to speak in support of a school must make their comments during this public comment window we are about to open. If you are on Zoom and want to speak, you'll need to raise your hand unless you're already on the sign-up list. To do so, click on the hand icon at the bottom center of your Zoom window. If you are participating by phone, you may virtually raise your hand by pressing *9. That's the star key, then the number 9. Our coordinator will call members of the public, starting with the pre-meeting signups, then the Zoom list in the order that they signed up or raised their hands. Staff will enable the microphone of the speaker and start our new on-screen timer when you begin to speak. If you cannot see the timer and you want us to tell you when you have 30 seconds remaining, let us know when you begin speaking. I understand that we do have people wishing to make a comment. So Devin, please go ahead and call the first person.
Our first public comment will be from Benjamin Cohn.
Hello, thank you. I think it's important in regards to the testing accommodation rules revision that you understand that you are considering accommodations that determine whether someone has access to their chosen profession. This is a very weighty liberty interest. The applicant will have already spent years and hundreds of thousands of dollars pursuing a career in law, and there is no other entity. It's not like you're providing a commercial service. It's not like you're providing an employment opportunity. There is no other entity from which they can take the examination that is required. And so these accommodation decisions are not something that should be denied because it imposes a slight burden of many hours of staff time or thousands of dollars of state bar expense to provide. This is controlling an applicant, whether an applicant accesses a profession that's worth a lot more than that to them. With that in mind, you have received written comments for this proposal from almost every major disability rights organization, major civil rights organizations, the California Access to Justice Commission, the authors of the Best Practices Report for the Department of Justice and California Civil Rights Department, formerly DFEH, Best Practices Panel, a co-author of the ADA itself, all providing the similar substantive recommendations and criticism of current rules and the proposal that was circulated for public comment, which I told you from the outset was insufficient reforms before you even circulated it. But now you should not circulate a new proposal that's similarly insufficient, locking it in for another cycle, or even worse, adopt this one. Yet the working group recommends rejecting the overwhelming, nigh unanimous substance of these public comments in favor of minor reforms. I went into detail into written comment as to exactly why they're still insufficient, but the working group is effectively proposing, even at best, even the faction that proposes to do the most, what's effectively a rejection of the substance of almost all of those public comments received. And you don't even know what public comments were submitted, but were lost by the State Bar's inaccessible form site portal, which it's already admitted didn't capture all the people who submitted comments to it. You found a few more in the
Thank you for
response
your
to
public
secure it.
comment.
Thank you.
Our next public comment is from Peter Maduro.
Thank you. Greetings. Thank you for taking my comments. I'm a clinical psychologist and psychotherapist licensed in California. I'm also a licensed attorney in 3 states. I've taken 4 bar exams as an able-bodied person. As a psychotherapist, I've worked clinically with more than one disabled patient who's prepared for requested testing accommodations, took the California bar with aspirations during entry into our legal profession. Among these patients, more than one initially had real difficulty and failed with the whole process and failed the California bar exam because, in my opinion, of inequities and inadequacies in the test accommodation applications, provision, and administration processes. Many applicants have emotional, even traumatic experiences and failed to pass the bar exam in California for reasons that are not the responsibility of the state of California. However, in a couple of the instances of my patients, their difficulties and failure, again, in my opinion, derive from unfair and insufficient testing accommodation processes and provisions. My hope is that the test accommodation rule revisions can be formulated ultimately so as to eliminate such unfairnesses by assuring a sufficiently level playing field between and among abled and disabled test takers. More specifically, 4 remarks, 2 weeks initial petition decision turnaround is needed instead of 60+ days. I believe this is important enough that you ought to hire additional staff if necessary. Number 2, applicants should get at least 30 days to appeal any denial or substitution of testing accommodations, so long as they petition at least 2 months before the exam. Third, unless there's undue burden on the state bar, no accommodation request should be categorically not offered for individual consideration or require attestation of exceptional need. Rather, what ought to be paramount, again, is that which best assures a level playing field between and among test takers. Finally, applicants should have the right to a hearing on denied requests for testing accommodations if they first appeal and second, their appeal can't be granted on the papers. This would be the same entitlement to a hearing extended to applicants who the state bar intends to deny on grounds of moral character failing. Why? Because the denial of requested test accommodations implicates the same liberty interest to pursue a chosen profession. Thanks so much for your time and consideration.
Thank you. Our next public comment is from Charlene Kalshay.
Hi, can you hear me?
We can, thank you.
Thank you. My name is Charlene Claich. I served on the Open Government Task Force for the City of Santa Rosa for a period of 9 months after Andy Lopez was tragically shot and killed by a Sonoma County deputy sheriff. 9 months I served on the Open Government Transparency. The California State Bar should be a role model in how they conduct their meetings, open meetings, noticing. It is highly unfair to submit a 250-page document on Wednesday afternoon and anticipate anybody is going to be able to give public 9 o'clock the next morning. Therefore, I'm requesting that item number 2, examinations under test B2B, testing accommodations, be removed from the agenda and give the public at least 30 days to provide public comment. 250-page document is really inaccessible for most people to digest in just a few hours and be able to give any articulate comments on that. I really think the state bar should be a role model in this, not doing just the minimum. That's the one thing I learned serving on that committee. And the city of Santa Rosa has adopted almost all of our recommendations. You post things much earlier than 20 or 48 hours before a meeting. I highly suggest that. If you don't pull the accommodations, I strongly object to the modifications based on people getting any additional time, private room, semi-private room, requiring them to repeat testing, very expensive testing, might I add, in order to get the same exact accommodations that the California State Bar approved for them from one exam application to the next subsequent test. If somebody has severe disabilities, they're not going to suddenly improve on those disabilities in a 6-month time period. Please reconsider those. I also worked for several mass tort class action. If you're looking to supplement your budget shortage, please start considering imposing fees on those out-of-state attorneys who are not licensed in the state of California to practice law and do not have a permanent place here. Tax them on their mass tort class action because they are the ones making the millions of dollars and the victims are making little. I signed up over 10,000 clients and made them $50 million. The money is there. Please start getting it from those that can afford to pay for it. The mass tort class action attorneys, some of them sit on some of the California bar exam subcommittees, and they should not be on there. I know what I'm talking about. They do not care about the clients. Mass tort class action should be highly regulated in the state of California.
Thank you. Our next public comment is from Ray Hayden.
Thank you very much. Ray Hayden here, and I'm kind of going off the cuff because I got notice of this at the last minute. Somebody said it's under section G, recent developments, and I didn't appreciate that very much because I try to be on top of everything that is coming out. Secondly, I can't see the timer and I can't see everybody all at once, and I don't think it's a setting that I did. And also, I can't hear the meeting very well, but I could hear Doell. I could understand her. Thank you very much. Okay, so I sent in a kind of a rough sheet on my proposal for an alternative to the California bar exam. So what I'm talking about here is that 114-page portfolio bar exam thing, which I think was shot down in the Blue Ribbon Committee, but I would wholeheartedly support anything other than what you have now, which is a mess. So, and I'm not criticizing California, I'm criticizing the MBE. The MBE has been determined to be invalid by both aisles and by the NCBM themselves, and they created it back in February 1972. So they're not a sitting attorney anywhere, and yet, thank you very much, has actually passed a valid bar exam because you're scaling the written to the MBE, which the NCB, the creator of the very thing, has determined is invalid. So that just, I want the psychologist back on there to explain the logic in that one for me. Anyways, let's talk real quick about the difference between the 114-page deal and my one-page deal that you all should have had, maybe two if it, when it's the next page. There's no scale, they're scaling. Their scaling has to go through the whole process and everything with that. And it takes 700 to 1,000 hours, which is 17 and a half to 25 weeks. That's insane. The February waiting point is 12 weeks. And the suggestion that I have is 8 weeks. It would take 8 weeks to do this. It's the February waiting from taking the February bar exam to getting results. This could be, my program could be up and running by July 2024, could have been up by February 2024, but now time's tight on that. I've done this before. It's been out for 20 years. I give it away for free. I don't charge anybody a dime for it. I do it because it's the right thing to do. The other thing is there's no scaling involved. You need a 100% to pass based on the FAA version of my program that's being used today. 100%, 99% correct is a 100% failure. You have to get 100%. Therefore, the materials are created by California Bar or scheduled to be created by California Bar. Everything's created from scratch to drill things into our long-term memory and to do well on the quizzes, which you have to get 100% on, which are also set up to drill into our long-term memory for the exams, which we need 100% on. 320 hours to get this done. Okay, instead of 700 to 1,000, and we have up to 480 hours to get it done, which is 12 weeks. 8 weeks to get the program done, 12 weeks maximum. Okay, now one last thing before I go. I agree with everybody else who spoke before me, and I would love to talk to Alex Chan, and there was a psychometrician, Tracy Montez. I would love to talk to them about my program because they're wicked smart. Thank you very much for your time. Thanks, Devin.
Thank you. Our next public comment is from Lee Farron.
Good morning. Can you hear me?
We can.
Okay, thank you. Good morning. My name is Lee Farron. I'm a program director at One Justice, which is a statewide support center that aims to strengthen the legal services sector's expertise and capacity to advance justice and equity. We join in the written comments from the disability rights advocates that were submitted, such as the Disability Rights and Education Defense Fund and Disability Rights California, and express our concerns that if the committee implements the testing accommodations rules as currently proposed, they will have a profound negative impact by reducing the diversity of attorneys who are allowed to practice law in California, an impact we are disappointed to see from the bar. Without being repetitive, we believe the bar should, at a minimum, ensure that their policies and processes comply with state and federal law regarding disability and reasonable accommodations. Thank you.
Thank you. Our next public comment is from Todd Hill.
Good morning. Thank you. Can you hear me? I guess is the question.
We can.
Thank you. My name is Todd Hill. Thank you for the opportunity to speak. I must note that the committee continues to operate in a fashion where it treats public comment as a term of origination, providing no reasonable access to written submitted comment after the fact, after it's provided. For those likely unaware of my ongoing issues, there is a case lodged with Federal Court, Central District, Western Division, numbered 2:3-CV-01298-JLS-PD. Forgive me for that. I repeat, the case number is 2:3-CV-01298-JLS-PD. I reference this to help inform others of the full scope and breadth of the issues. I also refer to Article 1, Section 3 of the California Constitution, the Sunshine Act of 2004. I'm a member of the public in distress, and I'm submitting this public comment in that fashion, in that vein. I do believe under that, the time restriction is inappropriate. Todd Hill first visited the People's College of Law in 2018. I matriculated in 2019. I'm a Black male, and although I'm fully qualified for American Mensa, I suffer from ADA qualifying cognitive attention and focus issues. This committee, State Bar, as well as State Bar, is expressly and constructively aware of all these facts. As the committee is both expressly and constructively aware, PCL was placed on probation by the State Bar, the sole regulator in the sphere of legal education services, effective December 2nd, 2022. As of today, August 18th, 2023, I've yet to receive my degree, a complete transcript, and a refund of funds. Not only has my degree not been conferred, I've been blocked from transferring from no fewer than 6 institutions, UCLA and UC Berkeley, which both operate under exclusionary rules that prohibit non-ABA transfers. UCLA is my undergraduate alma mater. I could not apply. Purdue Global and Abraham Lincoln were among the other schools. I had to apply for financial aid. I was stymied because I could not get an accurate transcript nor relevant information. The California State Bar was expressly and constructively aware that PCL was engaged in the practice of awarding substandard units. I was a diligent law student enrolled at People's College of Law in August 2019. Throughout this tenure, I worked very hard to excel at my studies. However, I encountered significant issues when I requested my official transcript from the school at the completion of my 1L year in the spring of 2020. It is 2023. Despite multiple requests and reminders to the school's administration, I did not receive an official transcript. The school's records inaccurately indicated that I'd earned only 2 units per course instead of the customary 3 for similar programs. I knew that this was incorrect information, and I could be negatively impacted by this, or my peers. State Bar was constructively and expressly aware of PCL's document noncompliance since at least 2017.
Thank you for your public comment.
As again, I've said that I'm in distress. I'm detained unlawfully.
Thank
and I've
you.
asked for additional.
Our next public comment is from Kendra Mueller.
Good morning. I'm an attorney commenting on behalf of Disability Rights California. We're the largest disability rights group in the nation, and we're also the agency designated by federal and state government statute to be California's protection and advocacy agency. I echo the overwhelming civil rights groups' commentary that were received and published through both verbal and written comment. And I urge the bar to do more research on the impact of their proposals for bar accommodations and not needlessly rush into approval. We've also submitted a more comprehensive public comment, but in regards to the need for more research to be done, one example is the decision to remove extra time and private room accommodations. This is aimless, as the research indicates that those 2 accommodations actually account for 77% of all accommodations. This negates the bar's inclination that the proposed rule will allow the ability to process the results more expeditiously. It will not, because for the majority of the requests, again, 77%, they will have to go through the regular process, which slows down both the bar's review and individuals in the disability community access to license. We also support the deference to an applicant's qualified healthcare professional, but that deference is again undermined by the language in proposed rule 4.1, which states that the bar's expert will decide whether the applicant has a real disability and truly needs an accommodation. Again, there's more research to be done on the deadlines for accommodation submission, as the current deadline proposed is misleading, as a first-time applicant may not receive the knowledge that they will not be able to appeal or get knowledge that their application was incomplete if they file at that deadline. Finally, the proposed rules lack a feasible communication system between the bar and the applicant to ensure that both parties can engage in the interactive process under both state and federal law. These are just some of the examples of why there is more research to be done, and we urge the bar to conduct that research. Thank you.
Thank you. Our next public comment will be from Deborah Meyer-Morris.
Good morning, State Bar trustees and the rest of y'all that are on this call. My name is Deborah Meyer-Morris. I'm an attorney for 31 years. My State Bar number is 158876. When I became an attorney, I was not disabled. Subsequently, as an adult, I sustained a TBI that affects my vision and hearing. Ordinarily, I need reasonable accommodations in order to read dense documents like the 250 pages that were posted about 24 hours before this meeting. There's been no way for me to request a a reasonable accommodation due to the short amount of time. It's really frustrating because only 5% of attorneys in the state have a disability and 2% of judges. In addition to being an attorney, I'm also an adjunct professor at a local law school. I've written in public comments in round one, which were completely disregarded by the committee because apparently the student I was describing was considered to be mythical. However, shortly after that, I did receive a call from the dean of my law school asking me to assist an older student, such as myself, who had never had any prior formal accommodations and was not required to take the LSAT. So they didn't have a history of requesting accommodations in a high stakes environment. I would suffer from the same deficit were I to apply to take the bar at this time. I would not be able to pass the bar without reasonable accommodations, even though I'm fully functional as an attorney and have been practicing for 31 years. The state bar really needs to address these inaccessibility barriers and real life problems that people have as adults attempting to take the bar exam. Not everybody decides to be a lawyer early on in their career. Myself, I obtained a master's degree during the pandemic after my car accident with reasonable accommodations from Cal Poly San Luis Obispo. I really want to urge you all to also consider the fact that my portal entry disappeared. I'm listed as making comments. I'm the last person on the spreadsheet. However, Ms. Herskovitz could not explain why my portal entry wasn't recorded. Thank goodness I also sent in an email with my public comments, which I urge you to review. The definition that you're purporting to use for disabled people is not consistent with the ADA, and you don't get to compare us disabled people to other people without using the definition set forth in required legal regulations. So thank you for your time. I also ask you to postpone ruling on this so that the public can have a voice, because less than 24 hours is not sufficient. Thank you very much.
Thank you. Our next public comment is from Beck.
Hello, can you hear me?
We can. It's volume's a little low.
Oh, how about now?
Good, thank you.
Thank you all. My name is Beck. My pronouns are they, them, theirs. I am the systems change advocate for the Dale McIntosh Center for the Disabled, which is a center for independent living in Orange County, California. We as an independent living center have submitted public comment for both rounds of public comment and would like to urge, as many others have urged before us, that additional time is being given for review of the 250-page document, and additionally that several of the proposals be rejected. But I echo everything that has been said. Thank you.
Thank you. Our next public comment is from Candy Smallwood.
Hi, she's coming in 1 second.
Hello, good morning. Can you hear me?
We can, thank you.
Okay, thank you. Sorry. Good morning, State Bar trustees and committee members. I'm speaking on behalf of Alliant International University, San Francisco Law School, hereinafter referred to as SFLS, and its application for approval as a registered unaccredited law school. My name is Candy Michelle Smallwood, and I am the program director of the Community Economic Justice team at the East Bay Community Law Center, a lecturer at UC Berkeley Law, and a proud alumni of San Francisco Law School, class of 2012. This year marks my 10th year as a licensed attorney in the state of California, and I attribute my successes to San Francisco Law School. When I reflect on my law school experience, I feel fortunate and grateful. Our small classes facilitated meaningful engagement, and our professors, some of whom were alumni themselves, had decades-long tenures at SFLS. They genuinely cared and continue to care about our professional growth and development. I managed to work full-time at a credit union while attending law school in the evenings. During times of struggle, professors would meet with me before or after class to review my exams. Saturday study sessions were available, and in addition to the bar prep courses provided by the law school, we had a robust bar exam preparation program. San Francisco Law School is a valuable asset and treasure, affording working individuals like me access to legal education without the burden of significant debt, which enables me to engage in meaningful community work. I am aware that SFLS has faced challenges in raising its bar pass rate. However, Dean Weimar is diligently allocating substantial resources to improve this rate, resulting in visible improvements. San Francisco Law School holds historical importance in San Francisco and has greatly influenced our careers and lives. I ask that you approve SFLS's San Francisco Law School's application for acceptance as an unaccredited law school. By doing so, you will provide opportunities for more individuals like me, a woman of color raised in San Francisco's public housing, access to a meaningful legal education. Thank you.
Thank you. Our next public comment is from Rhiannon Ross.
Hi, my name is Raymond Ross, and I am a graduate of SFLS, and I am also a born and raised resident of the city and county of San Francisco. SFLS is a very important institution as it relates to law in San Francisco because it provides those who cannot afford the traditional track of attending law school, which creates significant burden, but also doesn't create the opportunity for well-meaning adults to be able to care for their family while they pursue their legal education. My ability to go to SFLS really has helped enhance my legal career, working in the district attorney's office in San Francisco for more than 32 years. I have been able to go to law school at night and be able to obtain my Juris Doctorate degree. SFLS has provided the type of services and support that we would want to provide for those folks who have come from unprivileged backgrounds that don't allow them the resources to be able to do what traditional folks have done as it relates to attending law school. SFLS challenges in regards to its bar rate is something that they are working diligently on. We have provided and have met every other standard that the state bar has set. We urgently implore you to please consider accepting the application for SFLS to remain as an unaccredited law school until we finish getting our bar pass straight up to your absolute standard. Other than that, everything else administratively that has been asked of SFLS, led by Dean Weimar, has been met and has been solidified. And we ask that you continuously that you continue to provide SFLS with the opportunity to provide a quality legal education for those that can afford it and those that actually need it in San Francisco. Thank you so much.
Devin,
Yes.
Robbie has a couple people with him, I think, who wanted to make public comments in LA. So it might be good to intersperse them with the two remaining 3 or 4 or now more Zoom commenters. And just for everyone's information, we're going to cut off public comment no later than 10 a.m. when our time set item happens. So if we do have a bunch of people still want to make comments, those of you who are making them, if you could be as brief as you can, that will help make sure everyone who can be heard in that time is heard. So Robbie, you want to have one of the, how many commenters do you have over there?
Yes, there are 2 gentlemen here who wish to make public comment. I think one of them is on your list, Devin. So what was your name, sir?
Robert Lacara.
Mr. Lacara is here. And what is your name, sir?
Ismael Venegas.
Mr. I'm sorry, what's your apellido?
Venegas.
Mr. Venegas is also here. So, Devin, were you going to be calling the gentleman next anyway?
Yes.
Let's hear from both of them because they did take the time and effort to actually come to one of our locations.
Okay. All right, sir, why don't you go ahead? I think you can be heard from your seat.
Thank you. My name is Dr. Robert Lacara, and I am a 4L student at People's College of Law. I've had the unique position to attend Texas A&M Law School in good standing, and also the Monterey and Kern County Law Schools in good standing. I'm here to let you know that I am very pleased with People's College of Law. The other day, I was in receipt of $300,000 worth of law books. They are making a lot of progress. I ordered 8 transcripts the other day, got them immediately. I have access to the dean. I have access to great instruction that is very equivalent to what I received at an ABA law school and a CBE law school. I'm an adjunct professor at USC. I got my PhD at Claremont. I think I can recognize good instruction. They're a good law school. Keep them going to make the progress that they need to make, but I have witnessed that they have made progress. Thank you.
Okay, thank you very much. And Mr. Venegas, do you want to go ahead?
Yes, I will.
If that's okay, Devin?
Yes, thank you.
Okay, go ahead, sir.
Good morning, everyone. My name is Ismael Venegas. I'm a third-year student at People's College of Law, Robert's classmate. I'm also here to just to voice my support for for the college. It's been my experience, I guess, like COVID exposed a lot of vulnerabilities of the school, how it operates. However, the school has come a long way, and thanks to the oversight of Ms. Leonard. But the school continues to make progress. We're rethinking our operating models, our administrative models, and to make sure that these vulnerabilities are gone. That if something, whether it's COVID or anything else, ever happens again, these things are an issue in the future. I'm like Ms. Lacara, believe the education it's a great education. It's on par with that I received anywhere from my undergraduate studies at USC to graduate work at Harvard University. So like I said, I'm just here in support and just want to make sure that you all hear that that the students are very much aware of what it is, and that's mostly because of the transparency in which the board and our dean and our administrator have been operating. Thank you very much.
Thank you. We will go back to our online public comments. Our next public comment is from Travis Alexander.
Good morning. My name is Travis Alexander. I am an alumnus of San Francisco Law School, Alliant International University, and I'm speaking in support of the school. I've spoken before when we were before this committee, and the points that I have remain the same. San Francisco Law School, for approximately 100 years, has been an important institution in ensuring access to the legal profession for traditionally marginalized groups. San Francisco Law School was the first law school in California to actively recruit women to become students and attorneys. San Francisco Law School was the first school to actively recruit people of color and other traditionally marginalized groups to ensure that they had access to the legal profession. That has not changed during the course of time up to the present, including when I was a student around 2012. What I noticed in my classes was a great diversity, something that I did not see in my undergraduate or at other law schools. And this is something that I believe we cannot lose. Diversity is very important, not only with people of diverse backgrounds, but also from different financial needs. San Francisco Law School, by having the night program, offers the ability for single parents or people who have to work during the day or people who are changing their career later in life, offers them the ability to have access to this career. And it then brings viewpoints that will allow for better representation of clients. We cannot just have attorneys who all come from a single background and a single culture and expect them to be able to relate to the variety of clients that we have in the state of California. San Francisco Law School is a very important part of the legal education of this state, very historically important, and continues to be going forward. And so I speak in support of allowing the school to continue as a registered unaccredited law school to provide that time, that opportunity to get the bar passage rate back up with all of the efforts that have been implemented and get back to full accreditation so that the school can continue to support the community of California, both by supplying lawyers and by creating a resource for those traditionally underserved in the state of California. Thank you.
Thank you. Our next public comment is from Sophia Haniff. Sophia, you've been unmuted. We will go to our next public comment from Claudia Center.
Good morning. This is Claudia Center with Disability Rights Education and Defense Fund, and I also speak for disability rights advocates. I want to urge the committee to somehow forward a proposal that includes both automatic approvals for timed law school exams as well as automatic approval up to double time. Those are both very well established standards in other testing entity programs, and I'm not sure why the working group divided up those two principles as an either or. They should both be incorporated. I'd like to also emphasize that the proposed rules have the wrong definition of disability. Under California law, impairment is a disability if it makes the achievement of a major life activity difficult. Instead, the proposed rules adds new language, first time it is included in the state bar rules, that requires that the impairment make the person limited in a major life activity, quote, compared to most people in the general population. And that's new language, and that type of language, which is not part of California disability rights law, is often used to exclude high achievers with disabilities. And we often see that analysis included in the boilerplate that our constituents receive from the state bar denying their accommodations. And so that language should be stricken. It's entirely inappropriate under California law. That's a federal law standard that is often misused. The proposal does not grapple with the timeline issues that many of our stakeholders have described, does not fix those issues. most important is that we're talking about culture change here. We're talking about changing the way that the state bar manages and responds to disability accommodation requests. That means that we need new training, we need new leadership, we need new consultants. That was the lesson from the DFEH versus LSAC litigation. The change did not happen until there were new consultants, until Joan Van Tol retired from the LSAC, until the contempt motion was granted. You know, there's no plan here for new training, new culture, new leadership. Instead, there's a proposed rule that adds a seniority requirement to the consultants that the state bar uses. Also, last comment, you know, we all try to participate in this, but we're tired. So you shouldn't count the number of comments as reflecting where your stakeholders are because of the multiple comments cycles. Thank you.
Thank you. Our next public comment is from David Bronze.
Good morning. My name is David Bronze. I'm an attorney with the Law Office of Leach and McGreevy. I'm also the San Francisco Law School Alumni Association president. I'm commenting today in support of San Francisco Law School's bid to remain as a registered unaccredited law school. I'm concurring with all my friends and colleagues who commented earlier about the status of our law school. The school has been in full compliance with everything that the CBE has required of it in order to regain accreditation, except for the bar pass rate. I'm confident that the program that they have in place now will work and will bring people's scores up. It has already been doing that. We were very close at the last bar exam, off by only a few percentage points. So I urge the CBE to consider granting the law school's request to continue on as a registered unaccredited law school. It would be a tragedy if that school were to close. It's been in place for more than 100 years. It has offered opportunities to women, people of color, older adults, LGBTQ people, folks who wouldn't have an opportunity to otherwise become an attorney. And I just really think that it would be a really awful thing if they were forced to be closed. So I urge the CBE to consider their request. I don't have anything further to say.
Thank you. And our last public comment, we're going to go back to Sophia Haniff.
Looks like maybe she has, there she goes.
Hi, this is Sophia Hanif. I'm a graduate of JFK Law School in 2016. And I just want to say that we need more than 24 hours to read through a 250-page document. I think doing anything, giving us less than meaningful time to review the documents and to comment on it is not sufficient way of reviewing on an issue. So because everybody has work and other commitments, and if we are giving, such a short amount of time, we're not letting people, we're excluding input for people who are not able to go through the documents. Thank you for your time.
Thank you. We have no additional public comment.
Yeah, I want to thank everyone for their comments. And we will close public comment. We have a few minutes before our 10 o'clock item, so let's move on to the approval of the June 23, 2023 public meeting minutes. And I think we can combine them with the June 28, 2023 minutes. So we'll do B and C together if no one objects. Does anyone have any corrections or questions about the minutes?
No, I move to accept the meeting minutes.
Okay, then moved by Reyes.
Second.
Second by Brody and Torres.
Since it's his last meeting, we're going to give it to Mr. Torres.
Going to give it to Mr. Brody? Okay, thank you.
Roll call vote. Dr. Bolton? Robert Brody?
Yes.
Dr. Cow?
Yes.
Alex Chan?
Yes.
Jim Efting? Kareem Gangora?
Yes.
Dolores Heisinger? Larry Kaplan?
Yes.
Alex Lawrence? Esther Lynn? Bethany Peak?
I'm going to abstain.
Ashley Silva Guzman?
Yes.
Vince Reyes?
Yes.
David Torres?
Yes.
Paul Kramer?
Yes.
With 9 yeses and 0 nos, the motion passes.
Okay. For now, I'll put off the chair's report. I'm not sure I'm going to have anything, but hold that until later in the day.
Paul, I see Roger already in the attendee pool. We want to promote him now.
I guess the only issue would be that we said 10 a.m.
Oh, right.
Let's see. I think maybe we can do rule under examinations, action on revised rule 4.62 of the admissions rules, recommendation to adopt them following the return from public comment and transmit them to the Supreme Court. The agenda doesn't state the subject of the rule, but it is the first year and general bar examinee access to their exam results. Christina or Robbie or Dolores, who's going to lead this?
I will go.
Christina, do you want to just lay it out, and then if there's anything to add, I'll chime in, but I think this is relatively straightforward. Go ahead, Christina, if you don't mind.
Absolutely. As Paul has teed up, this is a rule change that would set a timeline for applicants to access their exam results. It's specifically Rule 4.62, which was circulated for a 60-day public comment period that ended on July 26th. This change would align the rule to our current practice, which is returning the exam scores and examination answers to applicants immediately upon the release of results rather than mailing the results. Through the applicant portal, the applicants can view, print, and download their answers and their scores, their result letter. The committee did receive one public comment, and the public comment did express disagreement. They suggested that there shouldn't be any specific cutoff for applicants to review their applicant files. However, the working group disagreed with this for a few reasons. The applicant portal itself has space constraints where we just can't continuously add to it without taking files out. And also the working group thought that there should be clear timelines communicated to applicants so that the expectations were set for up to 30 days for applicants to receive those exam materials and result letters. I think that summarizes anything. Robbie, did you want to add anything to that?
No, thank you, Christina. As Christina said, I think as we look at the CBE to tighten up our rules and make it easier for applicants to express any concerns that they may have about their scoring. This provides, free automatic downloaded access to your scores within 30 days of the bar results. That gives you time to express any concerns if you have any for an applicant and for the bar to act on those promptly. As Christina said, this was circulated. There was only one public comment that said, well, we should have unlimited access for indefinitely to those scores. You can get them after that by paying a fee because then I guess they're stored off the main server for our results. But I think this is an efficient way to process any requests to see your scores. This is from when you are notified that you did not pass the bar. Then you have an immediate online no-cost access to your exams for 30 days.
And
so I approve the staff recommendation that we adopt that timeline.
Okay, couple questions. Does anyone else have questions before I go? So Christina, Mr. Cohn suggests that the cost of keeping these things available via the portal should be de minimis. But I believe in the past, you've told us that you need to clear room in the storage, online storage system in order to do other things. Is that really a significant cost to the bar if we were to keep these available for longer?
That is correct. So first of all, we don't have space in the applicant portal to keep them indefinitely. What we do is that we remove the answer files in order to clear space for the next exam. So for example, the June answer files for the first year will be removed prior to the July exam being administered. July will be removed before the October exam, so on and so forth.
Okay, so you're sharing space for the first year exam materials with also with the general bar exam.
That is true, and it's not just the exam results, it's anything that's on the applicant portal. So that could include moral character, eligibility, transcripts, certificates of good standings. Any file that is on the applicant portal takes up space, and we're beyond our space that we have available to keep things indefinitely.
And it's not possible to purchase more space? I know you don't want to spend money on anything right now, but
I don't know if that is an option. I believe that somebody on this committee or on this screen has looked into that, and I believe it is a exorbitant amount of money for that.
Okay, second question. So the rule change uses the phrase "the exam answers from the last administered exam are available upon submitting basically a request and paying a fee." But are you mixing the two bar exams also for that, so that after, let's say we got a first year exam in June, and then the general bar exam is in July, are the first year answers no longer available at all once the July bar exam is administered?
No, in those cases, because it depends on what platform we're using. For ExamSoft, for the California bar exam, we use ExamSoft. So we can go back to ExamSoft up to the last California bar exam. So if the July is administered, we can go back to February's exam files and retrieve those for applicants. We just can't go back farther than that. So for those
So they're just lost forever.
I'm sorry.
Not archived in any way?
I'm sorry.
They're not archived, copied off to local storage or anything?
They are not, and that is really the same process we've been using. When we used to print and actually grade physical books instead of answer files, once we mailed those answer files to the applicants, they weren't, we didn't have access to them any longer. So that is keeping with our standard normal practice that we've always done.
I don't know, that seems to me to be risky. If somebody sues us, I don't think the statute of limitations has run, and we've already given up and expunged the evidence from our control. Okay, that's I guess a question for later, but I'd like to hear more about that. It just seems like a risky management practice.
Well, keep in mind, there are a lot of answer files. So for July exam alone, 9,000 applicants times 6 answer files per person. We're
Well,
talking about quite a bit.
much of the rest of the world thinks storage is cheap. That's the cloud. So, okay, I've asked my question. Thank you. Any other questions or comments? Can somebody put up the proposed motion? Anybody wish to make that motion?
This is Robbie. I'll move to adopt the staff recommendation.
This is Taurus, I'll second.
Okay, we have that. Devin?
Dr. Bolton, Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Larry Kaplan,
Yes.
Alex Lawrence, Esther Lynn, Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Vince Reyes,
Yes.
David Torres,
Yes.
Paul Kramer.
Yes.
With 12 yeses and 0 nos, the motion passes.
Thank you. Okay, how long do you anticipate Dr. Bolus's report will be?
Right, 30 minutes.
Okay, so then let's plan on doing that, and then we'll take a brief break, mid-morning break, and then we'll go on to the item H from Ed standards. So let's see, let me read the formalities. That item is item C under examinations, a discussion of the first year law students' examination performance tracking report.
Okay, I'll be introducing Dr. Bolus. So good morning, everyone. Dr. Roger Bolus has served as the Committee of Bar Examiners psychometrician since December 2014. Prior to that, Dr. Bolus worked under the direction of Dr. Stephen Klein on multiple projects related to the bar exam and the first year law student exam. Today, he will be presenting his findings on an analysis of the first year law student exam for exams administered between 2000 and 2021. He'll be providing the committee with some policy considerations. Lisa Cummins, principal analyst overseeing exam development, will also be available for questions. And so with that, I will hand it over to Dr. Bolus.
Thank you, Amy. Let's see. First of all, I want to thank you for the opportunity to present the results of a report that I completed in April on the outcomes of the California examination. I want to get to there we go. During the presentation, I'll plan to address 6 areas, a brief introduction to the history and purpose of the exam. I want to ground everybody in terms of the composition, scoring, and decision rules, talk about the research questions and the study data and design, go through briefly the key findings and some considerations that have come out of the research for potential modifications to the exam, and then a slide on other related projects that I've been engaged in. currently engaged in with the staff. So back in 1933, a report to the Board of Governors indicated that unqualified students were not eliminated in many unaccredited law schools, and only after failing the bar exam, after years of study, did students realize that they wouldn't qualify for admission to the bar. So in 1935, the first-year law exam was instituted under the Business and Professions Code 660H. In separate cases, the purpose of the exam was further defined, and I think it's worth reviewing these briefly. One was to deprive students attending unaccredited schools of their potential for eventually becoming lawyers, to curb recruiting abuses by unaccredited law schools, to protect persons from continuing to spend time, money, and effort in pursuit of a profession in which they're not qualified, and aid qualified persons in judging the quality of training and education they are receiving in preparation for the bar. So in terms of the current configuration of the exam, we know it's a one-day remotely administered and proctored exam. It's 2 sections to the examination, kind of mirroring what the general bar looks like. There's 4 essay questions administered in the morning with an hour per question, and a 100-item multiple choice test administered in the afternoon, administered in 2 90-minute sessions. As you all know, the exam is administered twice a year in June and October, covering 3 subject matter areas: contract, criminal law, and torts, all courses that are generally taught as 1Ls. And I'd note that the current format of the exam has been in place since 1999. Talking briefly about each of the sections, each administration has a unique set of questions written and graded by the state bar staff and consultants. Similar to the general bar, the exams are graded on a 40 to 100 point scale in 5-point increments. Each of the subject matter areas are covered by 1 or more of the questions. And about 3 months after the examination, the questions are released to the public along with the responses from higher scoring applicants. The multiple choice section basically has 5 100-item forms that are rotated. They've been in use since 1999. I comment that there is some item overlap between the forms. The current set of items in use were developed between 1996 and 1998. And since 2000, each of the forms have been used 8 to 9 times. The purpose of having multiple forms is to minimize the probability of applicants being able to access the exam. Each form has roughly equivalent number of items covering contracts, criminal laws, and torts. And currently, there's over 400 unique items in the current item bank. 200 new items were developed, but have not been tested until recently. During the last 2 administrations, 50 of the new items have been piloted as part of the administration. Each form contains a set of 20 to 25 equating items, and the purpose of those equating items is to be able to anchor the performance of the test back to the 1998 exam. Psychometrically speaking, that anchor test is somewhat dated, and so what we've done within the last 8 to 9 years is to also use results from more recent exams to aid in the equating of the exam. These are procedures that mirror what's being done by the National Conference for the multi-state bar examination. So in terms of scoring, a raw essay score is calculated based on the sum of the 4 essay questions. A raw multiple choice score is created based on the sum of the 100 items. At that point, a scale score is calculated for the multiple choice exam using the equating process that's been in place since 1998. And basically the function, as I alluded to earlier, of this equating process is to adjust for differences in the difficulty over time in between the forms. So what happens at the end of the equating process is the multiple choice scores based on a scale of measurement from basically 0 to a theoretical maximum of 400. The next step is to basically scale that written score to be put on the same scale as the multiple choice test, resulting in a potential maximum of 800 points. Note at this stage, the essay and the multiple choice are equally weighted, and the total scale score is basically the sum of the two scale scores. You can think of that 800-point scale similar to the Scholastic Aptitude test of 800. I couldn't find any documentation as to why this scale of 800 was maintained, but it's functioned reasonably well over time. So in terms of decision rules, if someone has a score of 560 or 70% of that theoretical scale, they pass. If it's less than 540, they fail. And then any scores in the middle go through a reappraisal process that I'll review. I just want to note that the cut score for the first year exam was established back in 1999. And the basis for establishing that was the decision that the new version at the time of the examination would pass roughly the same percentage of students as had occurred in the 3 to 4 years preceding that. In the reappraisal process, the grading leaders provided with all the information from the initial grading. They're also given a calculation of the number of additional points that would be needed to achieve the passing score. And the leader reviews all the information and makes a gestalt decision of either pass or fail. They don't affect the scores. So the purpose of the research project, as it was initiated in April, was several-fold. One was to evaluate the viability of the testing structure, that is the use of a multiple choice and written component, to evaluate the reappraisal stage, to determine whether or not the scoring methods and the weighting methodology that's applied is still relevant, and to look at the appropriateness of the passing standard of 560 scale points, which again was established 30 years ago. And then to look at the possibility of providing additional statistical results to the public that could aid in the decision-making process to continue law school and eventually take the general bar exam, which was in line with the stated objectives of the exam. So we had basically 3 specific research questions to ground everyone. How have examinees performed on the first year exam over time? Just to give you a sense of volume, what the performance was and how it's changed, and provide a little insight into what's happened with the differences between law schools and the demographic composition of the test takers. Then to examine subsequent experience of the examinees who actually failed the first time. I think you'll find that some of the statistics are quite telling to see what's transpired after somebody failed the examinee, how much improvement of scores occurred, who went on to sit for the general bar, how many additional attempts were made, etc. And then for the examinees who took and passed the first year examination, how many actually went on to take the general bar examination, how many attempts were made, and to actually look at the degree to which the performance on the first year exam is related to the eventual performance on the general bar examination. that's basically an assessment of the stated purpose of the first year exam, which is to become a leading indicator. Psychometrically, we call that predictive validity of the examination. And a few related questions. So to provide some context for the data, we looked at the data between 2000 and 2021. During that time, 24,000 examinees sat for the exam, 49% of which were first takers. We can see between 2000 and 2021, the number of takers peaked in the early 2000s and has been dropping rather steadily since then. I know that the results just went out for the latest June exam, and the June exam had 190 some odd applicants. In terms of the passing rates, we can see they have vacillated over time. The overall passing rate across that entire period was 22%, with a range of 17 to 27%. And on average, the passing rate is about 10% higher for first timers than repeaters. So from that population, we created a specific subsample. We first focused on first time takers, and for each test taker, we tracked them forward. In other words, what we did was what we call a longitudinal design. We took, for everybody who took the exam, we followed them up for 10 subsequent administrations for each test taker. So for example, June 2000 test takers, we actually tracked them through the October 2005 examination. And our analysis showed that almost everybody made 8 or less attempts. So we felt we had a pretty good coverage of that. So the resulting sample consisted of 34 separate cohorts of 10,340 test takers. The final cohort ended in 2016, which is why you'll see all of the results ending with that exam. That administration provided us sufficient time to gather subsequent experience with the general bar exam. So in terms of findings, our key findings, you see here that the majority of test takers have been Anglo. We could see over time, we could see a drop from basically 57% of the population down to 49%, and that continues today to decrease. We've seen an increase in the percentage of Hispanics sitting for the exam, with roughly equivalent percentages of Asians. Males and females, slightly more males taking the examination, but similar to the bar examination, we see increases in the relative composition of females. Students other than unaccredited, students going to unaccredited schools are allowed to take the exam for specific reasons, but we can see the majority of those sitting for the exam are unaccredited schools. We can see the, in terms of the breakdown of schools, there's been some bouncing in terms of whether or not they come from correspondence, distant learning, or fixed facility. We noticed that 53% made only one attempt, and we'll talk at length about that. Again, the majority of these students, 90%, were students coming from the unaccredited schools and taking the exam under what we call regular circumstances. This graphic shows a breakdown of the scores over. I clustered the time periods into 4 years. We noticed about a 10% drop over time in Asian performance, about a 13-point drop by whites. Hispanics, less of a drop, 3 points, and only a 4-point drop in Black performance, which is was the lowest of performing of the groups. If we look at the passing rates, we can see that 27% across time. By far and away, the group that passed at the highest rates were white, reflecting the average scores. Asians were next at 26%, and again, the lowest passing rate was among Blacks at 9%. A 5% difference between males and females, and the highest passing rate we noticed was among special applicants, and those are people who were either got their education in judges' chambers or other special accommodations. So we next looked at what happened to the applicants after they initially sat for the examination. We noticed that 73% failed on their initial attempt. Roughly 2/3 of those who failed decided to take the examination again. So roughly 1/3 of those who failed never took the exam again. One time and then basically quit. We noticed that some examinees persevered more than others. Actually, about 1/4 of those who failed attempted at least 3 or more times. Now, a lot of this was individuals who had passed on their subsequent try. We'll present some statistics. We noted that about 3/4 of those repeating the first year exam did show some gain. The median improvement was only 40 points, though. We noticed that that 40-point gain was consistent across their initial score range. So it's not as though those at the bottom of the range improved significantly more than those at the top of the range. It was quite interesting to me how consistent that gain was. When we looked at, when we modeled those gains and asked the question, did they vary by type of legal education, ethnicity, or gender? We saw no effect of those. So basically saying whether you're Black or you're white or you're Asian or Hispanic, on subsequent attempts, you'll see roughly the same average improvement. We did see that scores on the first attempt and follow-up attempts, the scores tend to correlate. Correlations are an index of relationship running from 0 to 1. Anything above about a 0.7 is considered a relatively high relationship. We noticed that the correlations were much higher on the multiple choice than on the written section, and we'll have more to talk about. So when we look at the relationship between the initial and eventual passing rate, this chart shows what on the x-axis here, what the initial score was, and what the passing rate was on their last attempt. So for example, those in the lowest decile of the group comprising about 10% of our repeater sample, if you had a score of less than 362, you had about a 3% chance of passing. So, which was virtually non-existent. To have at least a 50% chance of passing, you would have had to have scored somewhere between a 482 and a 496, which is considering a passing score of 560, we're looking at about 80 points below the passing score. And to have at least a 75% chance of passing, you'd have to have a score of 528. So you can see how strongly related the subsequent passing rate is to the initial score. Now, the report that I did replicated a previous report that we did back in 2010. We followed a lot of the same procedures. That report back in 2010 had tracked applicant pool predating most of the sample that we looked at. But what was very telling was the comparability of results. In the previous report, basically 44% had passed on either their first or subsequent attempt. Currently, we saw the same percentages. Similarly, the percent failing was virtually the same. When we looked at the total scores, we can see the comparability there as well. So I present this only to emphasize the fact that if you were to read the balance of that report, a lot of the findings in this report were very similar to what we found previously. And an earlier report that was done back in 2000 yielded similar results. So what happened after applicants sat for the first year exam? Basically, 35% of the students who started taking the examination out of the 10,340, only 35% eventually sat for the administration of a general bar examination. If we looked at the composition, the rates of people who sat for the exam remained fairly consistent over our 16-year period, varying only by a few percent. We did see the composition of those sitting for the exam slightly different, again, in terms of whites versus blacks. The eventual sample sitting for the general bar only made up 6% of the population, and as opposed to 62% of the population being made up of whites. Similarly, the race looked the same for school, and gender only differed by 3%. So what happened eventually for the general bar exam? We noted that 71% failed on their initial attempt. The initial pass rate for the first year law student takers were less than half the rate of all 148,000 first-time takers who sat for the general bar during that time. So basically 29% versus 62% in the general population. And I would note that that 62% is actually inclusive of these first-year takers. So if we were to take those out, that rate would look closer to 63, 64%. So quite a discrepancy. So in terms of perseverance, 83% of the failing applicants opted to retake the general bar. So they persevered at a rate that was higher than people who failed the first year exam and opted to retake. 80% of those repeating the exam showed some gain with a median improvement of 77 points. The eventual passage rate on the general bar, which was after all attempts that these individuals made, was 57%. So, which is basically twice as high as the initial pass rate. So of all the people who sat for the general bar, eventually 57% passed. If we reanalyze the passage rate based on the current 1390 standard, and those passage rates would have gone from 29 and 57 to 37 and 62. Since only individuals who passed the examination, passed the first year, were eligible to sit for the first year, there is a statistical method to assess what the correlation would be if we were to correct for the that truncation. And we noted that the first year exam scores correlated 0.7, which is quite high with the general bar examination. And again, we noted that relationship was much stronger on the multiple choice section than on the first year. This particular slide shows what the actual and predicted rate were at each of the final first year law exam scores. So we can see a range going from 541, which is the bottom of the reappraisal range, up to 700. Over our period of 16 years, we see the number of applicants who fell into each of these groups, the percentage that these scores represented of all first year takers, and what the actual pass rates were on the bar examination. So we can see an increasing rate running from 41% if you squeeze through as a result of reappraisal in this bottom rate, all the way up to almost 100% if they scored 700 or higher. And there were over 45 people or students who actually scored at that rate. Our modeling, this is just a note, showed that we could predict fairly successfully what the eventual pass rate was going to be and compared it to the actual rate. And in most cases, these only varied by 1% or 2%. When we replicated that at the 1390 standard, and we saw the rates increasing by about 5 to 6%. I'm going to skip over this slide for the benefit of time, but basically what this slide was intended to show is that at a specific score level on the first year exam, we can see that holding all other things constant, blacks will still score or will pass at a rate that's about 15% less than whites and Hispanics and Asians. And this, again, is holding constant the first year score. So in the report that'll be shared for you, this particular slide is further elaborated on with the point of wanted to make the point that there is, while the first year exam is particularly predictive of scores, there are other characteristics that will actually end up impacting final performance on the general bar examination. So kind of in summary, if we were to look at the 10,000 students that we tracked, we found that 66% never took the general bar exam. And that was comprised of the 53% who failed and 13% who actually passed their first year but decided never to attempt to become a lawyer. 34% of this group did eventually sit for the bar exam. And of those, 19%, we see that 19% out, or basically 1 out of every 5 students who initially took the first year exam eventually passed the exam. There were, just note here, this 1% who had failed the first year but eventually passed the general bar. There are a handful of students who eventually would transfer at some point in their educational career into either an accredited or an ABA approved school. And that's how they were able to make it into the examination. So with that as a background, we looked at considerations for potentially modifying the first year exam. We looked at the essay section, the reappraisal process, and the passing score. So two things came out of our analysis. One was the potential for actually adjusting the weighting of the examination. We noticed throughout the analysis that the essay section had a much lower reliability than the multiple choice, meaning that it tended to provide less consistent scores. When we looked at the predictive value of the first year law school exam scores relative to the general bar, we noticed that inclusion of the essay not only didn't improve the predictive value, but actually negatively impacted it somewhat. I saw no previous documentation from the current 1-to-1 section weighting. If it had occurred, it had occurred before. I know Dr. Klein and I were involved in consultation. My guess is that it tended to follow a similar weighting schema that was for the general bar exam. So what we did do is we did do some simulations with us asking what would happen if we were to come up with alternative weighting. We found that the overall exam reliability would have gone up by about 5 points. It would not have substantially have impacted the absolute passage rates, and it wouldn't have differentially impacted any of the demographic groups. If you recall, this is what we did when we shortened the bar examination, because at that time we also knew that the MBE was slightly more reliable than the essay questions. Another option would be to completely eliminate an essay section. Clearly, there would be an operational impact in terms of cost savings, reduction in testing time, and elimination of a reappraisal phase. I know people have argued that the essay portion on the examination could be used for diagnostic purposes, but we know because of the low reliability, this has been pointed out in past several reports on this topic, that the individual essay scores don't carry sufficient reliability to be effective for diagnostic purposes. When we simulated an examination eliminating the essay, we noted an overall improvement in the reliability. We saw that it yielded a first year score that was as predictive of GPX outcomes as one that included an essay section, and again, did not differentially impact passage rates on any group. Next, we looked at the reappraisal process. These scores are scores within the reappraisal range. Across the 16 years, these were the number of examinees who passed within those ranges, and it was expressed as a percentage of everybody who's passed. So if you were up at the top of the range, the probability of you passing was over 95%, going down as low as 73% at 542 and bouncing back up. If you were at a 540, you had a 90%. So overall, 92% of people who were in reappraisal eventually passed, which is an incredibly high rate. So looking at that, we looked at two options. One was basically lowering the passing standard to a 540. Again, there was no documentation for the current reappraisal range. We saw cost savings because there'd be less grading activity and a faster release of results. The net effect, if we had done this over 17 years, would have been to basically pass 91 more students, which would be about 5 to 6 passing per year. And based on historical rates, it would have been basically 4 more students taking the general bar exam per year. A more draconian activity would be just basically to maintain the 560 passing standard, but totally eliminate the passing standard, or to eliminate the reappraisal process. The net outcome of that would have been to fail about 1,616 applicants over that time, which would have lowered the eventual pass rate, but it would have improved the overall general bar exam passing rate, because we know that those students who were in those score range only had a predicted 39% passage rate. And all of this were based on just simple mathematical modeling. And finally, in terms of the passing standard, there were a couple passing standard studies that were conducted back in 1998. The problem with those studies is they found a very different perception of what the passing rate could be. Unaccredited panelists thought it should be set at a 538. The ABA school panelists set the standard at 574. And so the decision was, as I noted earlier, was to leave it at the point where 70% back in 2000 would be passing the examination. We know the press has stated that the first-year law student school exam has a reputation of being one of the most difficult law examinations in the US. I'd point out that it's not necessarily the most difficult examination, but it clearly has one of the more severe cut points or passing standards. And then similar to the general bar, the passing rate has continued to drop. It was 15% on the most recent exam, as has the number of test takers. Only 190 sat for the exam in June. The standards for education and psychological testing recommend passing standards be revisited every 7 years. And we note that the standards suggest that the passing points should be informed by both empirical evidence, which is provided in this report, and the input of subject matter specialists. There is a chart in the report that for the benefit of time, that I won't review, but you can see in the report that shows what would happen if, what would have happened if the score range had dropped, if the passing standard would have dropped. We could see obviously more people passing the first year exam, but the overall passing rate on the general bar based on the models would be expected to drop here from 56% down to 34%, depending on where it was set, and at 1390 going all the way from 61 to 37. So in closing, just want to talk about some related activities that we've been engaged in. The content specifications of the first year exam were reviewed by panelists back in June of 2022. Fairly good findings that the importance of the content areas, 97% agree that the areas were being covered, and that knowledge in the areas, 89% of the topics indicated that a first year student, borderline proficient student, should be knowledgeable of topics in the area. Coming out of that was some suggestions for new content areas and potential areas for dropping. We've had a review of all of the items currently in the bank, as well as all the new items. The results of that were fairly positive. We did identify some problematic areas for either modification or deletion, and I know the staff is currently working on that right now. And there's another statistical review of the individual items for looking at the psychometric performance of the individual items and looking at potential gender or racial bias in there. And finally, we have started testing some of the new experimental items during the two recent examination administrations with an eye toward potentially eliminating or modifying some of those items that have yet to be tested. So in closing, I would just point that in your review of the report, note that there are several opportunities to, at least from a psychometric standpoint, to improve the examination, activities that probably should be undertaken looking more carefully at the passing rates and strong consideration being given to the functionality of an essay examination on a first-year law student examination. So with that, I will stop sharing.
Are there any questions?
Go ahead, Amy.
Are there any questions for Dr. Bolus or Lisa?
Yeah, I have a question.
All right.
Dr. Bolus, thank you for your report. Pretty informative. I'm concerned that the statistics that you have with the racial ethnic categories of Black, Asian, and Hispanic, they either kind of been level, maybe a little bit of progress, but particularly for the Black population, it seems to have lowered. And so I think the considerations that you have in terms of adjusting the test may help on that. So the question I'm going to ask is, this may be beyond the scope of what you looked at, since you're mainly looking at numbers. But do you know if the schools where these students have attended are engaged in a lot of activity to try to help raise these scores? The reason I'm asking that particular question is because the unaccredited schools come up before us regularly because sometimes their score levels are too low, and that's one of the criteria that we have to keep the school accredited. So could you talk about that a little bit?
Yeah, I personally don't feel qualified because I'm not clear about what's going on curricularly within the schools. I would imagine, just based on the percentages that have been made public over time, is that they must be engaged in instructional and curricular changes, but I can't speak to the that would be probably subject to some specialized studies, which I'm assuming that the schools are engaged in, just to be able to track that. I do work with other law schools around the country, and I do know that they've been sensitive to dropping bar passage rates, and they are engaged in a variety of different changes, not necessarily targeted to certain racial ethnic groups, but just overall low scoring individuals. I don't know, maybe some of the staff who are more intimately involved with what's going on in the school can speak to it. And just one related point, the number of students who sat this last administration is 190. And that's a far cry from the 500 and 600 students that were sitting when I first got started in this area many years ago. So it leads me to believe that there almost by definition, there has to be, this is a very, very different population of students that are sitting for this exam than sat for it in the past.
And I think, Vince, this is going to dovetail into the next item that we're moving up from Ed Standards about law school performance. So I think that Natalie can comment about this, about your question in that report.
Okay, thank you. Thank you, Dr. Bolus, for your insight.
Yeah. And again, I apologize for inundating you with a lot of tables, but there's a lot more description in the report itself that might help elaborate on some of the points.
Okay, if nobody else has a comment, I have a question.
Alex has his hand raised as well, Paul.
Sorry.
Oh, Alex Chan does have his hand raised as well.
Okay, go ahead, Alex.
Appreciate your comments, Dr. Bolus. I only have a couple of questions for you. I'm looking at one of your slides. This is slide 19, where the graph indicates the percentages of students passing on the final attempts. And so I'm looking at, the graph, and let me know if I'm reading this correctly, but it sounds like about 76% of examinees do pass on the final attempt. Am I reading this correctly? Meaning, setting aside the percentages for the initial attempt, but the final attempt, you have 76%. So, I mean, that number, are you suggesting this number should be higher or lower?
No, I'm not actually making any suggestions. This is just a presentation of fact. What that, just to clarify, what that is showing is that if an individual scored a 528 on their initial attempt, meaning that they failed the examination, if they opted, if that group opted to retake the examination, 3 out of 4 of them would pass. This is not to say 76% of the entire sample would pass, but if you scored a 528 or higher, you would have a 3 out of 4 chance of passing. And the reason why I put this in the report and in the graph here is I personally believe, and this is editorializing a bit, but I personally believe that if I was sitting as a law student and trying to decide whether or not I should retake the examination, and I scored a 362, which was quite low, I would give a lot of thought to whether or not I would want to go through the agony of retaking the examination if I knew I only had a 3% chance to pass. Now, again, I could be that one person or one of the 3 people out of 100 to pass, but I would want to know what this information was.
Understood. And looking at your slide number 30, where potentially the 2 considerations for us, one is either to lower the passing standard to 540, and the other one is maintain the current passing standard. Are you suggesting one over the other? And if so, are you okay? So you're just putting that out there, and it's the purpose to increase the percentage of examinees passing on the initial attempt?
Well, it's just to inform you as the state bar considers potential changes or activities with the examination of a best guess as to what would be happening if you were to address a modification to the passing rate. It's, because we know from all of this data is that if we let in lower performing students, and by lower performing I mean based on their first year performance, a good number of those in that lower score range really don't have a high probability of passing the examination. What it would tend to do is it would increase the passing rate on the first year examination, but it begs the question is that if the purpose of this examination is to serve as a screening mechanism, you want to basically maximize the eventual outcome on this and be as predictive as possible. So wherever you go with looking at the passing standard, just know that these would be the projected outcomes of what would be what one might expect.
This is helpful. And finally, I think you already said this, but I just want to confirm it. In preparing the deck, you haven't really, have you real? I think you already said this and confirmed it, but I don't think you have sort of reviewed the curriculum at different schools in sort of ascertaining, the fundamental reason behind the decrease in the percentages. Am I correct?
Correct.
Okay.
It would require, at least from a quantitative perspective, it would require a little bit more information than we have here and in the state bar's records. We require having some information about the incoming quality of the students, their, you know, what courses they're taking, et cetera, et cetera.
Yeah, so in my opinion, the first year law school exam is meant for those students enrolled in the state bar and unaccredited registered law schools or through the law office study program. And so by design, the baby bar is really to test these students who do not receive traditional education in order to accommodate, things like their personal or family obligations. And so I think it is certainly incumbent upon these programs, the schools, to set a high standard to prepare these students to ultimately pass the general bar exam and practice in California. And so the piece of information I would like to have in considering whether to make the suggestion to Supreme Court, because after all, it is the Supreme Court that decides, whether we should lower the passing standard from 560 to 540, for example. But the piece of information I certainly would like to have is whether the schools have, met the standards in preparing the students. And certainly I appreciate all the analysis. This was tremendously helpful. But, maybe for the next agenda item that perhaps we, you or someone else could analyze the curriculums for the past 10, 20 years and see whether there are positive or negative changes that may have explained the decrease in terms of the pass rates. But anyway, I think I have said it all. I would just, I would just end here and thank you again, Dr. Bolus, for your insightful comments.
So Alex, just to note, the Supreme Court sets the cut score for the bar exam, but not the committee sets it for the first year.
Oh, that's very helpful as well. Thank
Anyone
you.
else? Okay, question and then a comment. So Dr. Bolus, when you were comparing eliminating the written portion of the test entirely with changing the scaling or the ratios, it wasn't clear to me if you thought that eliminating it entirely was improved the predictive value even more than the changed ratios, or about the same?
At the 2/3, 1/3, meaning 2/3 for the written section, 1/3 for the or for the multiple choice, 1/3 for the math, that came close to. I'd have to go back and look specifically at what the rates are. I have it. It's in the report at some point. I never made a direct comparison because in my mind they were fairly radically different modifications. I looked at the elimination of the written section. Again, that recommendation was made in the 2010 report. Maybe not as a formal recommendation, but as an option. And again, the reason for presenting the one table was to just basically show how comparable these results have been over time. So this is not a one-off finding. But in thinking about dropping the written section completely, it did operate effectively as a standalone solution, and had the value add of a lot of potential cost savings. And in testing, one would includes multiple modalities if you believe there's a need for the multiple modalities because you're testing skills that a particular format doesn't allow you to. And second of all, you think it's going to improve the predictive capacity of the overall administration. And I guess in trying to model the response here, I think the option of eliminating the written section met both criteria, which is why I presented it. I'm not advocating either one, but I don't think, mathematically speaking, the alternative weighting was was significantly better. I'd have to take a closer look at that to see what we came up with.
Okay, well, I think that would be important to informing our future discussions. But when I heard about the weighting, when you described it, I assumed that the written test would be given less weight, and the way you just described it, it sounded like you were giving it more weight. Did I mishear you? Or did you?
Yeah, just to clarify, the current weighting is 50-50.
Right.
And I looked at this similar to what we did when we shortened the examination, the general bar, which is.
But aside from what we did then, I'm just trying to understand what you're. Did you analyze giving more weight to the written than?
No,
less weight.
Less weight.
Okay, I think you you got them reversed a minute ago.
Oh, okay. Apologies.
Okay, and so if you could be clearer about those points in the final report, and then also I'm sharing here, these slides will often be taken out of the context of the whole slide deck by people. So take, for instance, this slide. It appears after a slide that said you were now talking about general bar exam passage rates. But somebody has to remember that. And if somebody pulls out only this slide to make a point, they won't necessarily know that they're talking about general bar exam passage rates. So just adding in the title here, the word GBX before examinees, I think would clarify that. And there's more opportunities to make these clarifications throughout the slides that you have. So I hope that you and staff can go and look and make sure that what these slides are actually saying is more clear from the context of the individual slide itself and not its placement in the overall slide deck. Does that make sense to you?
Yeah, I fully understand what you're talking about.
Okay, great. Thanks. Staff, is there any particular, we're just receiving this report to get our brains cooking, I presume, right, for future discussions?
Correct. We're going to disseminate the report next. And I also want to highlight that we have two more questions. Leah and Dolores have their hands raised.
Okay, Leah?
Yeah, just on this slide that Paul has up. So Dr. Bolus, you're saying this slide relates to bar exam pass rates?
No. This is actually.
Yeah, I didn't think so.
Yeah. This is what happens in reappraisal for.
Okay.
Yeah.
For first year law student. Okay, I just wanted to clarify that.
Yeah, thanks, Leah. That's exactly right. Basically, that slide was intended to show, bottom line is that almost everybody who goes into reappraisal has been eventually passed.
Okay.
Okay, so I picked the wrong slide to make my point, but please, my point stands, I think.
So I wanted to just sort of pose some questions for the committee that I hope you consider. I do believe, I know later today you'll be going over your work plan, and I think broadly sort of looking at your role as overseers of the registered schools is part of your work plan. And so just to kind of think about these questions that I'm certainly thinking when I'm reviewing the data. If I'm looking at this correctly, Dr. Bolus, of about 10,000 students that you looked at over, I think for a 16-year period, perhaps, ultimately about 2,000 of those people actually passed the bar exam. You can correct me if I'm wrong, but I think that's the 20% of the 10,000. All right, so we've got 8,000 people who paid some amount of tuition and have never succeeded in becoming lawyers. And so I think one question I have is, are we performing our consumer protection function in allowing that result? So that's a macro level question. The other, sort of looking at the next level down, one of the things that you hear about these schools is they're schools of opportunity and you have a more diverse student population. And certainly I think perhaps it is one of the additional items for today, you'll see that it looks like that is the case for the initial classes at these schools. But again, when you look at who's ultimately passing the bar exam, I'm not so sure that you're seeing that diversity carry through into our licensee population. So again, questioning some of the like core foundational arguments that we hear for the need for these kinds of schools, really asking yourselves, does the data support it? So I think that's really important, and I ask you all to consider that as part of your deliberative process. The last thing has to do with the very practical conversation we've been having about fees. You know that very shortly, the board will take action to significantly increase fees, including fees for the first year law students exam. What we see in Dr. Bolus's report is not only that the essay portion is not adding value, but perhaps the exam is more reliable without the essay portion altogether. The essay portion is costly. We are undertaking a very involved process at this time to update the questions, the item bank, which hasn't been updated in many years. And I ask you to really, in sort of the very near term, think about what information you would need to have to make a decision quickly about whether or not it's time to eliminate the essay portion of the exam. And I think, Paul, that's I understand your question about, what has greater validity, elimination or changing the weighting. But I think having that conversation absent the sort of parallel conversation about fees is not useful, because if you did eliminate the essay portion of the exam and you're hearing that the exam would be more reliable than it is today, it would also be cheaper for the state bar to administer and therefore for exam takers. So those are kind of my big level asks, I think, of you as the committee as you navigate this, your overall charge in terms of overseeing unaccredited law schools, and then your very particular role in the near term related to the costs of these endeavors for test takers on the bar. Thanks.
Dolores.
Yes, back to Vince's question about what the schools are doing to help us, particularly the ethnic minorities, in doing a better job of passing these exams. I'm curious, whatever happened to that program that came before this committee a couple of years ago with a great deal of fanfare that was designed to do exactly that, to help students who were in the early stages of going to law school and particularly aimed at ethnic minorities to help them succeed, that was like designed around stories. Whatever happened to that program?
Oh, that was to reduce anxiety for the bar exam takers?
Yes, it's called the Bar Exam Strategies and Stories Program. It's a positive mindset intervention, and we continue to offer that. I think we had a hiatus in 2022, but we recently offered that program for the July 2023 exam. So it's ongoing.
And what's the uptake on that?
We can invite the researchers back to provide us input on report back on how those students who participated fared. But we have reports that there is an increase in the pass rate for those that participate in that initiative.
Did you have something else, Dolores?
Yes, is that offered through the bar or through the law schools?
It's offered through the state bar. We have, we allow in the application process, as people apply for the bar exam, they're invited to participate in that program. So it's an invitation that's offered to every applicant, every bar exam applicant.
Amy, maybe you can talk about efforts to expand it to applicants for the first year law students exam and where we are on that.
Yes, so we've reached out to the same researchers to possibly extend that program to the first year law student exam. We're exploring how much that would cost, how long it would take to get that program up and running, because it's simply not just an initiative that it could be easily adapted to another exam. The researchers have to research more about the exam itself to design the components. But yeah, so the possibility of having a positive mindset intervention for first year law student exam is something that we are currently exploring with the same research team.
And Dolores's comment puts me in mind of a much bigger initiative that I think has gone by the wayside. That was something called the Educational Pipeline. Leah, Donna, do you remember that animal from some years ago? And do I have the name close to correct? The idea was we're going to start maybe as early as first grade and gradually encourage people to want to get into this profession among others and provide educational support.
There's the high school pathways, and then the 2x2x2, 2 years community college, 2 years in a UC. Maybe it's 2x2x3, and then 3 years in law school. That is sort of an articulated program in the state system with participating community colleges, undergraduate institutions, and law schools. So that does exist, and there are the high school law academies. That was seeded many years ago, or founded many years ago, a partnership between COAF and some other Department of Education, State Department of Education entities, and that still is underway. That's looking at the pipeline into law school.
Well,
that still exists.
I think it is important to try to remedy deficiency in somebody's education into their early 20s. At that point in their life is more difficult than if you provided the opportunities to them early in their lives and their educational experience. But it's also a massive undertaking that we cannot afford at this point. Okay, so what is next, Amy? We'll talk about the work plan at the end of the meeting today. I made a note that we should check it to make sure that talking about the first year law students exam is an element on the work plan if it isn't already. Do we need to receive and file this report, or is this report still to be drafted in its final?
Yes, we're going to bring the report back to the send it out to the CPE, and then we could discuss it more. But today was basically a discussion and just orientation on the topic itself.
Okay, well, for me anyway, I found this very stimulating, various thoughts, and Dr. Bolus, thank you for what must have been a lot of work.
Thank you.
Okay, break time. Our next item would be the testing accommodation rules, and I think that's going to go for a little while. So for planning purposes, would it bother anyone if we plan to take a break for lunch at 12:30 for half an hour? Is that going to work? Anybody seeing nods? Okay, so let's plan on that, and we will take a 8-minute break right now, picking a random number between 5 and 10, and we'll be back to deal with our next item, which will be the report from the educational standards portion of the agenda.
here is okay.
Okay. How about exactly 11:28? We'll come back.
It's exactly 11:28.
So, I mean, that is so unusual for us to be exact about that kind of thing, but you know, this has been a year of setting precedents for me. So let's go on to the next item as promised, and that is under educational standards. Item H, report on law school performance pursuant to a state bar strategic plan goal to protect the public by enhancing access to and inclusion in the legal system. Natalie and Jim?
Sure, thanks. Jim, do you have any opening comments while Devin brings up the presentation?
All right.
You're
Maybe.
echoey, Natalie. Am I?
Yeah, do you have something else open with the meeting on it, your phone or anything?
Oh, no.
I mean, it is gravitas to your voice, but it's also harder to understand.
And now you're muted.
Okay, does that help at all?
No. It's okay. I mean, we can all hear you. It's just an echo.
So sorry, I know that can be really distracting. I'm gonna see, I usually use a second laptop or just give it away to see if it has any type of interference.
Over here, we are not achieving the clarity that Audrey is.
Okay, does that assist at all?
You know, Natalie, that was happening to me because I'm also on Zoom. So I turned off not only the mute, but I turned the volume off on my laptop, and that seems to have stopped the echo. I don't know if that's helpful to you.
Let's see.
Natalie,
What about?
Natalie, log out and then join back in.
Okay, I'll see you in a minute. In the meantime, I don't know if you want to continue on to the next. But I'll be back.
If she said something about minutes, we did those already.
Oh, she said she'd be back in a minute.
Oh, back in a minute, okay. I will have to say that generally speaking, the system that the bar has in its conference rooms works surprisingly well.
Thanks, Paul. Well, we can promote Lisa Chavez, and since she collaborated with Natalie on the report, maybe while Natalie's logging back in, introduce her.
Has that helped at all?
Oh, that's much better.
Oh, I'm glad.
And we were going to just have Lisa introduce herself since she collaborated with the metrics.
Terrific, please do.
Oh, Lisa, you're on mute.
Good morning, everyone. My name is Lisa Chavez. I'm the director of the Office of Research and Statistics, and my office collaborated with admissions on the production of this report. So looking forward to our conversation today.
Okay, welcome. So I'll get going with the sound. If it appears that there's any issue, just let me know. We certainly do want to be able to share what we have to say and also to hear your questions. So at this point, I'll ask Devin to bring up the PowerPoint related to the metrics, and I'll also thank ORS for putting together this report for us today. So I think that we'll talk about the metrics in general, and it will also relate to some of the other questions that we've gotten. We'll be talking about exam performance in here, as well as the overall composition of the schools. A little bit later today, we'll also be talking about the NPR reports from the accredited schools, where we can further talk about the efforts that schools are making. And we'll have an inspection report as well from an unaccredited law school. So this report was created in satisfaction of one of the elements, the work plans related to the element for the strategic operational plan of the Board of Trustees, Goal 2, as Paul mentioned earlier. And this is our first attempt to do this. So we focused on gathering data that is already collected either through the annual report or alternatively through additional qualitative work that the Office of Access and Inclusion has conducted through surveys and also focus groups. In the end, we selected 20 measures to present to you as an initial review, and they're included in this report. So Devin, would you skip 2 slides? We'll go past the introduction to the first chart. Okay, so the first chart talks about the number of CALs and unaccredited schools. And if you look at recent years, you'll see overall there's been a decline in the total number of schools participating in the program, but it's been a relatively steady number in the past couple of years. But a steady number doesn't always mean no change. So in this case, we've actually seen quite a bit of change in recent years, change of categories, change of modalities. So if we look at these last couple of years, we see the following coming into the unaccredited program. That would be Lincoln Law School of San Jose, Southern California Institute of Law, and Pacific Coast University School of Law. We see the following other programs coming into, other schools coming into the accredited program, coming from ABA approved status, Thomas Jefferson and University of Laverne. Coming from unaccredited to accredited status, Concord Law School, St. Francis Law School, and also Northwestern University, California University. We've also seen several schools close in the last 24 months, and that includes San Francisco International, American Heritage, and Pacific West. So even when numbers stay stable, there really may be change. Okay, next slide.
Sorry, Natalie. Devin, can you change the display of this presentation?
Does that look better?
Yes, thank you.
Okay.
Thanks, that will be easier to see. Okay, this slide looks at the teaching modality, and we think that the pandemic greatly accelerated change in this area. So historically, unaccredited schools must select a category, whether correspondence, distance, or fixed facility, and that's why you see those only in those categories. And then accredited schools use a slightly different format, and they can also use mixed modalities. In the past, accredited schools were required to have a fixed facility program with the students physically standing together in the classroom. The enabling rules for that were changed in 2019, and the first accredited online or hybrid programs beyond the pilot ones that were approved for experimentation were permanently approved in 2020. We see more and more of the accredited schools adding a hybrid or online option. You have a request on the agenda today from San Joaquin College of Law to do so, for example. In the unaccredited realm, some of the schools that were operating in a total distance format took the opportunity to apply for accreditation, and 3 of those so far have earned accreditation. Those 3 that I mentioned earlier, St. Francis, Northwestern California University, and Concord, all moving into the accredited space now that that was possible. Previously, that format itself would have prevented them from seeking accreditation. Okay, next slide, please. In recent years, we've also seen a very large change in the total number of students attending the unaccredited and the accredited schools. This presentation is more about metrics than about the whys, but some of the things that were going on out in the environment at this time were the following. First of all, schools were becoming accredited, as we discussed, leaving the unaccredited category, even though some did enter the unaccredited category. Another thing that happened was that during the pandemic, the preference for, or perhaps the acceptance of online education may have improved, and the opportunity to attend an accredited distance school also became available for the first time. We also see other jurisdictions outside of California considering the possibility of having these graduates take their bar exam. There is a slim opportunity to do so in Texas. There is a very controversial proposal in Indiana as well regarding that, for example. So at this point, about 88% of the students are in the accredited program, about 12% in the unaccredited, even though the total number of schools is relatively similar, 18 and 12. Next slide, please. Okay, so this gets back to what we were talking about earlier and a little bit toward Vince's question as well. This is looking at the 2022 JD enrollment by demographic characteristics in the CALs and the unaccrediteds. So we see that about the majority, we do not know the race or ethnicity of those in decline to state, but amongst those identifying, the majority are white. But if we compare to the general licensure in the bar, general licensure is approximately 65% white. We do see a more diverse profile here, particularly if we were to make the assumption that all of the decline to state unknown is white, we still would see a more diverse profile in both the CALs and the unaccredited schools in approximately similar directional proportions. In terms of gender identity, it's relatively recent for the state bar to add a non-binary choice. And you can see for this time, we're showing you for the first time the breakdown, including non-binary individuals. And we see what we see in the ABA schools as well. At this point, the minority of students would be men. It's very different than what we saw in the past for law schools. Next slide, please. Thinking about the price and the investment to attend law school, the CALs generally are at an average of about $75,000 for the total JD. The reason why we look at total JD is because the CALs might offer a 3-year program or a 4-year program. They can offer a full 3-year full-time program if that is approved for that school to offer, or they certainly can offer the part-time program. Comparing to the unaccredited, unaccredited students must study for 4 years. Their programs are by design and by statute part-time programs over 4 years. So this way you can do a direct comparison what someone is paying in total. And I think it's also helpful to see not only the amounts, and we do see that an accredited degree can cost as much as more than twice what an unaccredited degree does. Although many of the CAL schools at this point, also through their regional accreditation, have access to Title IV fund student loans to assist the students in paying for their tuition. This is relatively recent, last 5 years development. But in the CALS profile, I think it's helpful to see a breakdown by school, and we'll show also for reference unaccredited. So on the next slide, you can see the various costs to attend the JD from a number of schools. And so in the CALS profile, you'll see the most modest cost from Northwestern California University. That is a completely online, largely asynchronous school, although it does have the required verified academic engagement to be an accredited school. And that total tuition for the full JD is under $20,000 at $16,395. And it is a very large school. So when looking at the average, I think if we were to simply remove that one school, we would see a higher overall average for the CALS. By comparison, if we look at an UC in-state tuition profile, generally the tuition is in the $50,000 to $60,000 range per year, so approximately $150,000 here in California. There are other public schools that have lower in-state tuition, but in order to attend those schools, it would require the student being able to relocate out of state. Private tuition would track the state tuition or perhaps be higher. In the unaccredited, there is less of a variation, but we are starting to see more and more variation than we saw previously in that category. Okay, next slide, please. So this is something new that we have not shared with you before. We've been building up to begin to look at this data over a number of years. So the first change that we made in our reporting was to change the demographic profiles to more closely match what the ABA provides to allow more comparison. The next thing we did was to start to look at 1L attrition in general and also by reason. One thing to be aware of is that this is self-reported attrition. So this is what the student tells the school. And we're looking here at the same type of measure that the ABA uses, which is non-transfer attrition. So if a student is leaving one school, but directly moving on to another school, that data is not continued. That data is not included in here because we don't consider that person to have attrited. They just continued their legal education at the school of their choice. But with that said, in these profiles, we might see more students that possibly do eventually return. If they've been academically disqualified, they may be required to sit out for a 2-year waiting period to prepare to return and have more success, hopefully. Alternatively, if they've left because they do have another circumstance of life, a family care, a job change, etc., they may need more time and they may return at a later point. But taking the data we've got, this is self-reported student data after the first year. It's important to realize that if these students have left between the first and the second year, that this could be a combination of their experience on the first year law students exam or their personal choice prior through academic disqualification. Overall, we see for those that started at a given year, and in this case, we use 2021 as our base year. When we looked at that same exact student cohort in 2022, 42% did not return to a CALS program. The number was higher for unaccredited, the cohort that began in fall 2021. 51% did not return for 2022. By comparison, if we think about what the ABA tracks, if a school has 20% or more attrition over time for a number of years, the ABA will consider this to be a compliance issue. If we look at the most severe attrition, we see that in the categories of Black students, Latino students, or multiracial students. And that is true in both. We do see 100% attrition for Native Hawaiian and unaccredited, but that is also a small sample size. Okay, next slide, please. Okay, so now we're breaking this down between the CALS and the unaccredited, looking at an academic reason or other reason. And a lot of the students, unsurprisingly, in this class of schools versus ABA schools are leaving for reasons other than academic. Thinking about this data, we've made some changes to the way that we do inspections and the way we work with and counsel the schools. And these are around communication and the admissions process. We would like for schools to know more about what the reasons are and how those reasons can be addressed, if any. If it can be clearly communicated, the reasons people have left in the past, if it can be clearly communicated, the amount of time that's needed during time and how that might affect certain common profiles. I travel a lot for work. I'm caring for my parents and my children at once. I'm planning a move, any other type of common circumstance that they see. So we can address not only the academic issues, which can be solved through academic support, but also these non-academic issues as well. We also continue to work with the schools to talk about the counseling resources available through the LAP to the extent that mental health support could help as well. Okay, next slide. Okay, so here we're looking at the exam pass rates by test taker status for the first year law students exam, but we're just focusing on 2022. So we're picking up where Roger left off in his analysis, but we're just looking at a tiny snip of data. The exam is offered each year in June and October. You can see the pitfalls in looking at just one exam. Many of these schools have multiple starts per year. So many people in this group probably hear school bells every late August or early September. For some time now, schools have also started a January class pretty regularly. And during the pandemic in particular, in the last 2 to 3 years, we've seen many more start times. So depending on the school, for some schools, June is the first opportunity to take the exam. For others, October. We know when we look at the bar exam in aggregate, there will be more first-time takers in July, not as many, usually in February. We can't say that in the same way for the first-year law students exam anymore. Consistent with Roger's results, we see the first-timers performing better and then those that come back and repeat. And he talked a little bit about long-term repeat profile. Here's something important to think about on this slide. The first year law students exam is required of all students who are in unaccredited schools, but it is required of some students who attend CALs, or some other CALs require it of their students sua sponte. So let's think about what that means. This data says that perhaps it should be discussed more frequently at inspections when a CALS accepts someone who's required to take this exam. So for example, someone who's been academically disqualified, or someone who does not have the standard pre-legal education. They are allowed to do so, but they must offer the resources needed for those students to succeed. We would have hoped that the results for the CAL students would be even higher than those for the unaccredited, but it's not what we're seeing. So this definitely warrants further thought and investigation. Next slide. Okay, so this slide looks at first year law student exam pass rates 2012 to 2022, just in the years that data was posted for public release. So some of that data was not during the period in the middle of the chart. That's why you see the breaks in the lines. Taken alone, we might spend more time on this, but this is pretty consistent with what Dr. Bolus was discussing, that you can tell pretty early on that the first time takers are going to have a higher pass rate for this exam. Looking at a companion slide on the bottom, looking at the bar exam, that holds true as well. For the CALs, it's important and helpful to see that the first time pass rate is 36%. And if you'll recall, we'll talk about the NPR later today. The Cal schools are required to keep a 40% or more NPR. So they should be aiming for that 40% each exam. We see that among the first time takers, and more support could be used for those repeaters, those that might be more at risk. Same thing true with unaccredited. Notice that the Cal's opportunity to pass generally overall higher. Opportunity to become licensed. Next slide. Thanks. Okay, so breaking this down by ethnicity, race and ethnicity, and also by gender. If you see a column that's missing, there's a place where, you know, generally in the exam results, we redact cells less than 11. So if it's missing totally, we haven't included that data. It was a very small sample. If it says 0%, as you see on the bottom, then we had a cell of 11 or more, but it rounded down to 0. So if we look at who is passing the exam, again, we see that while the profile, consistent with what Leo was saying, while the profile of the class is generally more diverse than the current bar, and remains so even at a pass level, the most successful passers are still the white passers on the exam. And interestingly, though there are more women than men in the classes, we see more success for the men taking the bar exam than the women. I'm focusing on the first time takers in my comments, but we would see something relatively similar in most of the repeater segment. Although it is interesting to look at the white repeater figure for the unaccredited schools, maybe a little higher than one might expect. Okay, next slide. This is something we've also been thinking a lot about internally. If we look at the trend over time, recently we saw a severe drop in the unaccredited first-time test taker pass rate for the bar exam. And we think that a lot of things could be at play here. Some of them we talked about earlier, a shift of schools, a shift of student preference, etc. So you will probably be hearing more from us in the future about this as we have more data to learn more. Next slide. Okay, here we're looking at the July 2012 to 2022 bar exam pass rates for first-time test takers by race and ethnicity. You talked a lot about the pass rates for Black students, and that's the yellow line in the middle. It's the one that is easiest to see. It's hard to draw a specific trend, and I wonder, Audrey, do we still have Roger in the audience? I'm not sure he was able to stay.
No,
I
he's
don't
not.
think so. No, he's not.
Okay, I just didn't know if he might have an additional comment. But we see relatively stable, yet not relatively clear trends. Next slide. Okay, by gender identity, women are the green line, men are the blue line. We see more women entering, but we see more men on a percentage rate basis passing. This is generally true for almost all points over a longer period of trend. And so it would be interesting to know what is behind some of these trends. Next slide. Okay, here's a really important slide. At the end of the day, the hope is that these schools will provide opportunity for students to not only graduate with a JD, but also become licensed if they choose to do so. Here we see about 18 schools versus 12, yet we see 530 of the degrees in 2022, the total of number of JDs awarded coming from the CALs. Just 72 came from the unaccredited. That's an average of 6 per school, when an average class in most of these schools is anywhere from 20 to 50. So this is not the number that we would hope to be seeing. We would hope to be seeing a higher number. And we know from Dr. Bolus's study that the number of JDs that you see will be less than the total number of licensees that will eventually enter the bar, particularly in the unaccredited realm. Next slide. If we look at that breakdown of how those JDs were awarded by demographic category and also by gender, we see that the majority of the degrees were earned by white and Latino students among those who identified. So we see a little bit of a different profile graduating than we saw at the beginning. If we look at the gender identity, we see about 39% of men, 58% of women in the CALS realm, 43% of men, 33% of women in the unaccredited realm earning those JDs. So when we think about how many more women there were at the start, we don't see them persisting to graduation in the same proportion, unless there is data to be found in the decline to state, which is rather high for the unaccredited schools. Next slide. This is the data that we track for employment outcomes so far, and we'll be interested in the committee's thought about how it should be tracked in the future. It's been tracked this way for a long period of time. What we do each year is the school surveys its graduates who graduated 3 years ago. The idea behind that when it was created was to give students the time to graduate, to take the bar exam more than once to become licensed, and then to indicate what their outcome was. Have they moved into a job where a JD was maybe not required, but is an advantage to have? Or have they moved into a job where a JD is required? The 3-year runway gives enough time for to make sure that licensure is less of one of the barriers to this. But we see, if we look at the survey response rate, the second column, the number of students responding varies widely by school. So it would be helpful to think about how to get that rate up in the future, to get more information from students, and to understand what sort of additional information, if any, the committee might like. Would you like more data from more classes year by year? Would you like more data about the types of areas that they enter, for example, government versus private sector versus individual practice? Okay, next slide. Okay, these last couple of slides just talk about what the current licensee profile is, and are students from these programs, both unaccredited and accredited, persisting all the way to licensure. The categories here are your ABA schools, the blue bar on the left, out-of-state ABA, CALs, unaccredited, and the other unknown is generally not truly unknown. It's largely licensees that earned their degree outside of a US jurisdiction. Could also be, for example, law office study in that category as well. So we see the vast majority of the licensees coming from ABA approved schools, whether in-state or to a lesser degree out of state. Total participation from the CALs and the unaccredited schools is hovering in about the 5% range. Next slide. Okay, and this is a foil for the earlier chart we saw. We saw the demographic breakdown in the CALs and unaccredited, if you'll recall, about 34 to 36% white in the CALs at the start of their class in the 1L year versus 65% of the overall bar, 64% in the CALs. I'm sorry, in ABA approved, 53% in the CALs. So it's just nice to have that background. And then in the gender area, you see majority women entering CALs and unaccredited, but a little bit less so by the time they graduate. We still definitely see a clear majority males in the licensee population. Okay, are there any questions?
Hey, Natalie.
Sure.
Hi, this is, oh, I'm sorry.
Oh, go ahead, Brody. Go ahead.
Hey, Natalie, thank you as always. That was an excellent presentation. I have a quick question. Do you have any data or collect data on students who identify as veterans?
You know, funny you should ask that. This is the first year that we've done so. This year we added veteran data and self-identified disability data. This is important to know, not only to serve our veterans, but also because there have been some changes in the Department of Education rules regarding where GI Bill funds can be used. So there's some flux going on in that space.
Yeah, that was exactly my interest, because I know that between the GI Bill and the Golden Ribbon Program, there is a lot of money for continuing education for our vets. And I wonder how much of that money is going into law school programs.
Previously, the accredited schools in particular, a couple of them come to mind specifically, had a relatively robust veteran population. At least one is in an area with a base and where there are significant retirees. But the changes no longer allow those specific funds to be applied at the accredited and unaccredited schools. It was passed a number of years ago, but only implemented in the last couple. So we don't have historical data about veterans. We weren't collecting that before, but it is something we'll be able to present to you in the future.
Great, thanks, Natalie.
Yeah, just to follow up what Robbie was saying, I was interested in that as well. I'm a veteran myself. It was my understanding that some of the veterans who were applying were having problems with the GI Bill at some of the Cal accreds, right? Was that a problem?
Yeah. So it's not that they generally weren't applying at the unaccredited schools, but they previously could directly apply their GI Bill, but now they can no longer do so. And so some of the schools have responded with loan programs for the veterans for whom it makes sense to undertake their education through their own loans rather than using their GI Bill funds, but their GI Bill funds are no longer able to be applied there.
is there any way that the California bar can work with these schools and to try to encourage the federal government to assist these veterans, or to get the GI Bill to work with these Cali-accredited schools?
That's
Have you
something.
looked into something like that?
That's certainly something we can look into. The schools were very vocal during the consideration process when the Department of Education, Department of Veterans Affairs were thinking about the rules. And at a certain point, the State Bar did submit a statement to the state legislature, a resolution just continuing to offer a positive feeling and support to continuing those programs. The recent decision was not to include them, but that's something that could be looked at again.
So there appears then, on another note, that there has been an increase over the past couple of years, or would you agree that there has been an increase over the past couple of years in the number of Latinos and Blacks in passing the bar from Cali-accredited?
Let me actually double check that before
Yeah.
I am responding to you. It's certain, I think that you'll see that more in the Latino students, Latino applicants. Than the Black applicants at this particular point.
Has the Black passing rate remained static over the years, or?
I don't have access to extremely detailed data at this point, but that is something that we can look at, and I think that you'll have more information about in the future. The reason why we will have more is because we've adjusted the demographic categories, number one, and then number two, starting with the end of the transition period this year, the accredited schools will be required to have a written, documented diversity, equity, and inclusion plan that includes analysis of outcomes disaggregated by race and gender. And so that's something we'll be able to bring to you in the future at a much greater level of detail than we can today.
Thank you, much appreciated. Good job, Natalie. Good job, Ms. Chavez.
Thank you.
So Natalie, were we going to talk about some next steps here?
Yeah, so as far as where this goes at this point, in a couple of directions. One is to share this with the Board of Trustees in fulfillment of the work plan requirement. But the other one is, this is the first time we've had an overall convocation like this in a while. So put in the context that Leah mentioned that I would amplify, I think it's important for us to think about what this says about the school programs, what they can provide, what they can contribute to the licensee population, and where you should be investing the State Bar's limited funds in the future. So specifically, we can be looking at the types of metrics that should be tracked, what you see now or what we could be doing in the future, as well as where your emphasis will be between these two programs and other choices you can make.
And so what's the plan? So I know we were going to be coming back to the CBE. I believe we were going to be talking with CS bars as well in terms of identifying, sort of narrowing in on those performance metrics for future reports, right? As Natalie has said a couple of times, because of the timing of when we were producing this first report, we were basing it on the data that we had, and we're not requiring schools to report data that they hadn't previously given to us. This is our opportunity to say, going forward, this is what we think we need to be analyzing in order to determine the efficacy of the programs that are being provided. So we want schools to start reporting X, Y, or Z. So we are going to be coming to you, coming to CS bars, having that conversation. But Natalie, do you have a timeline for when we might provide a draft and be able to have that discussion?
Well, pending the information that we get from the Board of Trustees presentation, This is something that we can begin to discuss at CS Bars in October, or potentially October and December, depending on how much time must be needed. I would like to get it into their hands sooner rather than later to get more information, so they can have it in mind when the annual reports are open on their desks. And also to give as much notice of any new type of measures that you might adopt, because as a practical matter, sometimes measures have a long lead time. They need access to certain students, and in particular, the 4Ls that may graduate, it's much easier for them to survey those students when they're still students versus when they become applicants. So we'd be looking to try to have a recommendation as early as possible in the new year from the committee. So potentially CS Bars in October, further discussion potentially December/January back here at the committee, so that something could be incorporated into the 2024 annual report.
And I think this also dovetails with a recommendation that the committee has put on its work plan for several years in a row, looking at the key question of should accreditation be mandatory, and as a result, eliminating any schools that remain unaccredited. There's some really interesting data in this report that you might see among the key takeaways, including just sort of the question of numbers, right? We know we spend a lot of time on the regulation and the oversight of unaccredited schools. There are 562, I think, enrolled in the schools, so fairly small number. Graduated 72 individuals. And one of the key benefits that we always talk about with some of these schools as schools of opportunity is the ability to provide opportunities for individuals who otherwise can't attend a 3-year in-person full-time law school, provide them some real opportunities to get the education and become members of the bar. But the statistics are telling us that the numbers that are graduating are pretty low, and the numbers who graduate, looking at this report and the prior report in conjunction, the numbers who ultimately are able to gain admission to the bar, who are able to pass the bar, are significantly lower at the unaccredited than from the CALs and certainly from the ABAs. And I think these are some important takeaways that the committee needs to be thinking about, and that we'll be bringing back to you as we're looking at sort of follow-on activity from both of these reports.
So imagine a world, for example, in which 58 counties in California, each county selects 2 promising students and enrolls them in the law office study program. That would produce 116 attorneys through that program versus the 72 that were produced this year through the unaccredited schools. So that's just some perspective, something to think about.
Donna, I'll also note that it appears that that particular task has fallen off the work plan again. So we'll talk about putting that back at the end of the meeting today.
Yeah, absolutely, Paul. I think that's part of that discussion that we were talking about earlier in terms of the oversight role and what the committee will want to be looking at. I think those are, I think it's really helpful to be at a point now where we've got some data that helps us understand what may or may not be the right decision. And so, letting that data take us where it needs to, I think is an important next step.
Any other questions?
Thank you. Do you require any sort of motion?
I think I see a hand from Kareem.
Yes.
Oh, sorry, Kareem.
Is it okay if I speak, Mr. Chair?
Sure.
Okay. Thank you. So thank you for the presentation, all the background, the statistics. It's something that I think has been very, very informative for me. I'm just trying to capture, there's been discussion in the past about the value of a law degree and that impact as well. So I guess I'm just trying to look at this holistically and the intersectionalities of it. How do we evaluate that component as well? Or are we only looking at this singularly from a bar exam test taking perspective?
Well, there are a couple of ways that we do make allowance for that, Kareem. So the first one is when there's a minimum pass rate, and there's a required one for accredited, but there's an optional, there's a non-binding one that the unaccrediteds report. For those that never take the bar, they're not included in that number, so the school is not penalized. So for example, the peace officer that hopes to be a police chief one day and will benefit from the knowledge but does not plan to practice, they would be excluded. The only ones that we're tracking are the people that actually do take the bar exam. And part of the issue is that the value of the JD degree is that it's generally understood as a degree of certain sufficient content that should give every person the opportunity to take and a reasonable opportunity to pass the bar exam. So that's part of the meaning that's baked into that JD degree. A student may not choose it, but it should have that content of that quality to give them the choice that they need, but also what the market expects.
So let's say that the unaccredited opportunity doesn't exist, then that degree ultimately goes away. Not goes away entirely from a state perspective, but just from that access perspective. Is that kind of accurate or inaccurate?
That may be so, although other opportunities would remain and more in California than elsewhere, but also query the positioning of a degree that over a long period of time is not enabling students to take and pass the bar exam, and what meaning should be interpreted from that type of degree when that's the outcome that's later seen.
Okay. Thank you, Natalie.
Natalie, what's the percentage of the CaliCred that provide online degrees? I know we've got something similar to Concord, because if you were to eliminate the unaccredited, you still have, and I think Kareem had alluded to this, individuals who do attend these unaccredited for the sole purpose of achieving a JD with absolutely no intention of becoming an attorney. And that's going to eliminate that possibility. But I'm just curious, if you do eliminate some of the unaccredited, what are we looking at in terms of the options of achieving a Juris Doctorate degree for some of these schools, say for example, or some of these areas, say for example in Riverside or some of these places in California that don't have access to?
Yeah, so at this point, nearly every accredited school has either a hybrid or a fully distance available option. And even those with a hybrid do have an exception for a fully online JD. And in fact, so much so that we see not only more inquiries from California individuals, but also out of state individuals who are now wanting to access an accredited online degree. So I would say it's pretty common, and today you'll get to see an example of what San Joaquin's program is proposed to be like. And that's an area that's less served by law schools, so it's good to see that in that area you may have not only the in-person, but also the online option.
Except that the cost is about double or triple what the unaccredited.
I'm double checking my sheet, but it may be more so. Yeah, it's 87,350 at San Joaquin, but by comparison, for the last couple of years, if someone were to choose that one, since it happens to be on the agenda, and we'll be talking about this later, for the last several years, that school's pass rate has been sufficient that it would exceed the ABA pass rate requirements, but yet at about half the cost of the ABA schools. So that's another lens to look through.
Okay, anyone else have any questions or comments? So again, Natalie, you don't need any sort of motion.
No, that's correct. The next steps here will be to prepare this information to transmit to the Board of Trustees and then to bring back to CS BARS for discussion, and then the committee to look at proposed expansion of metrics. But I would be remiss if I didn't again thank Dr. Chavez and her team, not only for this data, but for their engagement, their patience, their strong questions that gave us some excellent ideas that we hope will help you in your regulatory goals here at the CBE.
Okay, thank you. I'm going to stick to my promises at the end of my term as chair. So we're going to break for lunch at 12:30. Is there, I don't think we'll finish the testing accommodation rules. Is there, what would you recommend, Audrey, that we tackle to use the remaining 11 minutes we have?
Maybe the cost analysis. I think we could probably go to that one, Tammy's item.
Okay, good idea. So under operations and management, item A is the February 2023 California bar exam, the general bar exam cost analysis. Bethany and Tammy.
Good morning, everyone. So the agenda item lays out what the costs were for the February 2023 California bar exam. As it reflects, we did hold this exam across 10 test centers throughout Southern and Northern California. The February bar exam for 2023 was a total of $2.8 million for 4,125 applicants versus $3.2 million for 3,451 applicants during the February 2022 bar exam. There was an increase of 19.53% for the number of applicants that we had for 2023. So that was a nice increase from what we had seen coming right back off of the pandemic. Some of the highlights for the cost analysis are that we did see a decrease in our overall cost when we had the February 2023 bar exam. Some of that is in part to February 2022. We returned from the pandemic and dealing with COVID. We had to hire a vendor that was helping us to track vaccinations as well as negative tests for everybody to sit for that exam. So that was an additional cost. We also, at that point, had started working with PSI. PSI Services was providing 500 proctors for us for the February 2022 exam. So with that additional cost of PSI in there, on top of the fact that there was an increase in the proctor rate that we were paying them for their hourly pay, that is accounting to why we saw the higher increases in 2022 versus the reduction in 2023. The other highlight is that for the February 23 exam, we used approximately 66% of the overall capacity for our test centers, compared to 69% for the February exam. The February exam did have a little bit of a different setup because of COVID. We were putting one person per table versus our standard 2 per table. And so because of that, our capacities were lower in 2022, but because of the 1 per table, it ended up filling our sites better than what we did in 23 based on our capacities going back up and putting 2 people per table. And so with that being said, I'm going to turn that over to Bethany, and she's going to continue to present the highlights and take it to motion.
Yeah, so continuing on from where Tammy left off, so generally or historically, about 81% of all of our costs for the bar related to facility rental, electricity, and proctors. And for this examination, we spent approximately 65% on those costs. Now switching over to comparing the costs associated with the testing accommodation compared to non-testing accommodations. For the February 2023 exam, about 9% of the applicants were at testing accommodation centers, and that number is 371. And these 9% of applicants accounted for about 43.6% of the total exam cost. And just for comparison purposes, for the February 2022 exam, testing accommodation center applicants made up about 8.2% and accounted for about 40% of the exam cost. And then, for the applicants that were at testing accommodation centers, the cost to facilitate the exam for those applicants is about $3,831 per applicant, compared to $415 for each applicant that is not at a testing accommodation center. And so just to round this all out, the overall cost for applicants, regardless of whether they were at testing accommodation or not, was $679 for the February 2023 exam. And comparing that to February 2022, where the total cost was $942. But as Tammy alluded to, that was largely due to a lot of those additional COVID-related costs. And so at this time, I'll ask Devin or whoever is responsible for the PowerPoints if you'll put the motion up. But we have a proposed motion, which is to approve the February 2023 California Bar exam cost analysis. And so at this time, I will see if anyone would like to move, and then we can have discussion if there is any.
This is Robbie. Hey, Bethany.
Hey,
I will
Robbie.
I'll move to approve the cost analysis.
I'll second that. This is Torres.
Wonderful. Thanks, Robbie and David. All right. So does anyone have any questions, or is there any discussion on anything we've addressed here?
Yeah, I do. So do we have a sense of what the fixed costs are? You know, those that don't vary much according to the number of test takers are. I know that these costs don't include, for instance, the cost of our exam graders or any or most allocated staff time. The reason I ask is, you know, we're going to be asked to evaluate or perhaps create a new bar exam, but also create an alternative. And as we've seen with the first year exam, when we have fewer takers, the cost per applicant, you know, zooms up because there are so many fixed costs. So I'm wondering if we can ever get a more complete accounting for what it costs to give the bar exam, you know, taking into account all the money we spend.
So I think we can work on bringing something back to you guys so that you can see what those costs look like.
Okay, that would be nice. And then my other question is it fair to say that with regard to proctors that unlike the old saw that, you know, government's better contracting out to the private sector for some services, that it, in fact, it did not result in any savings in this particular case?
So for the February 2023 exam, we did all of the proctor recruitment ourselves, but we were still paying the same hourly rate that we had implemented back in February 2022. I do think there was some savings there because, of course, PSI was providing the proctors, and of course, there was probably, I'm assuming, a service fee that was included in their overall cost to do that for us, plus paying their proctors. However, we definitely took that on in February 2023. We did have temps in February 2023 to still offset, I believe, but not as many as we could have normally. So overall, I think we did better in February 23 with our proctors ourselves versus asking somebody else to do it.
Yeah, I mean, there's a group of people that always say the government should contract out everything, but your mileage will vary, I guess, is the lesson. Thank you.
Donna has her hand raised.
Yeah, so one of the things that I'm a broken record about pointing out every time we present this report, and this is an add-on to what Paul was saying, when we talk about the cost per applicant for taking the exam, we're focusing on a very narrow set of costs here. These are direct costs for the facilities, for the proctors. When we did, for example, the work to identify what are our overall costs to put on the bar exam, not, not a particular bar exam necessarily, but for a given year, we allocated staff time. We looked at the costs for consultants for testing accommodations, review of testing accommodation applications. When we put all of those together, so we did have that number, Paul, if that's what you're looking for in terms of sort of what was the total cost of putting on a bar exam for a given year, because that number is different. It is very different than this number, because this number just looks at direct costs, and I think it leads to some confusion, frankly, in the general public, looking at this saying, well, it only costs you $415 to administer the bar exam to me, and you're looking to increase the amount that I pay from the current $667 to $850. Well, that's not what it costs to administer the bar exam, and so I've always harped on this number because I think it's misleading, and it contributes to an incorrect narrative that we've been hearing over the years from some members of the public.
So we received this report because we're required to, is that right?
I was asking that question in the chat. I'm not.
Because if we're just doing this in a way that causes, grief for us, if you will, rhetorical grief, and maybe we should consider reporting, the more representative numbers rather than these, even if it's only once a year, for instance. See what I'm saying, Leah?
Yeah, but we couldn't do that same analysis that we did sort of every year. But I think this is sort of something that has historically built up over time as the committee was looking at how are we spending our money, right? And so I also sort of question, if this is the report that's going to give you the best information, or if there is something else that we can commit to doing on a periodic basis, and maybe just bringing to the committee if there are particularly significant spikes in some of these costs, making sure that the committee is aware of that. But otherwise, having every couple of years something that really does the same kind of analysis that we did to determine whether we were covering our costs with the revenues that we were
For me, I don't find this report particularly helpful, and I wouldn't miss it much as long as we had a periodic, less periodic analysis of our fundamental costs. Again, the question I'm trying to answer is, if we create, let's say we have a pool of people who want to be admitted to the bar every year. And if we shuffle half of them off to an alternative program that's going to have its own costs, and yet we have very large fixed cost, non-variable costs for the bar exam part, we're going to have to raise the bar exam fees quite a bit. I mean, maybe we think that's a good thing to do. I mean, we haven't had that discussion yet, except by implication. But it's something that I want to take into account in making that recommendation to the trustees and the court. So whatever you can do to better inform that aspect of my curiosity would be appreciated. So do we have any other questions or comments before we vote?
I just wanted to say, I think that looking at the direct costs exam by exam, like as trends, could be helpful for the committee, and that's probably the genesis of where this report came from. But absent of the indirect cost, the total expense picture is not very clear. So I think that's a good takeaway for me and for Tammy to think about this less of an analysis as like a trend in how the directs are moving over time.
Yeah, if we talk about just these costs, we tend to then start talking about how many people sitting at a table and all the little micro details that we should be able to entrust to staff to deal with, rather than the big picture. And I've been trying to be a big picture guy as much as I can in my role in this committee. So anything else? If not, we have a motion on the table. Devin, did you get the maker in the second? You're all set to ask? Take the
I
vote?
did.
Go ahead.
Dr. Bolton, Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Efting,
Francisco.
Yes.
They're in San Francisco.
Kareem Gangora,
I guess.
Yes.
Dolores Heisinger,
Yes.
To provide ADA compliant.
Larry Kaplan, Larry Kaplan,
He said yes.
Yes.
thank you. Alex Lawrence, Esther Lynn, Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Vince Reyes,
Yes.
David Torres,
Yes.
Paul Kramer.
Yes.
With 13 yeses and 0 nos, the motion passes.
Okay, let's take 30 minutes for lunch. So we'll come back at, let's have one more minute, 1:05. You're welcome.
Round off.
Sorry, Paul, what was the time again? 1:30,
1:05.
1:05. Thank you.
Thanks, Devin.